persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 25-1591. National Treasury Employees Union et al. Versus Russell T. Vought in his official capacity as acting director of the Consumer Financial Protection Bureau and Consumer Financial Protection Bureau appellants. Mr. MacArthur for the appellants, Ms. Bennett for the appellees.
Good morning, counsel. Mr. MacArthur, please proceed when you're ready.
Oh, yeah.
And just
Just
for the
go ahead.
benefit of everyone
just
here,
move
in
it's not
addition to the
touchscreen.
judges who you see before you, Judge Henderson is also joining us by audio. Please proceed.
Thank you, Chief Judge Srinivasan, and may it please the court, Eric MacArthur for the federal defendants. I would like to reserve 5 minutes for rebuttal, if I may. I'd like to begin with 2 points on which I hope we can all agree. The first is that, as we have said all along, the executive branch lacks the authority to close the CFPB and has an obligation to ensure that it performs its statutory duties. Second is that our system of government cannot function the way it is supposed to if courts overstep their own authority and prevent the executive branch from carrying out lawful reforms for which the American people voted. We are now more than a year into a new presidential administration, and still the injunction entered by the district court in this case last March prevents the Bureau's new leadership from carrying out, exercising their lawful discretion to carry out the president's deregulatory agenda by downsizing the CFPB. That injunction rests on a series of legal, factual, and equitable errors, and it represents a serious affront to the separation of powers. It should be vacated. Now, there are a number of threshold issues in this case. The place that I would like to start is with the issue of channeling. I want to start there both because I think that issue is relatively straightforward legally and also dispositive of the most problematic part of this preliminary injunction. That's provision 3, which prevents the Bureau from conducting a reduction in force. I say it's dispositive because I think if we're right about channeling, that provision of the preliminary injunction has to go, even if we're wrong about everything else in
So
this case.
this is not critical for liability, but it tees up your scope of relief argument.
I think it goes to both liability and scope.
Well, you
of-
have other plaintiffs who we think have standing.
Right, but standing doesn't address the separate jurisdictional barrier of channeling.
No, I understand, but channeling only knocks out the employment-related plaintiffs. Then you have a different set of plaintiffs who are consumers of agency services.
I think, Judge Katsas, that channeling knocks out the employment-related claims of any of the plaintiffs, not just the employee associations. It knocks out any claims related to or premise.
Fair enough, but we're still going to be having the same over whether this shutdown decision can be inferred from everything else or challenged on constitutional grounds.
That is correct. This wouldn't be dispositive of the entire case, and we still would have to confront all of those other issues to determine whether, as we say, the injunction should be vacated entirely. But I do think the channeling issue, if we're right about that at a minimum, means that the RIF prohibition, which frankly is the issue I'm concerned about the most, has to go.
So you say that that the RIF claims, any RIF claims have to be channeled to the CSRA, but as I read the CSRA, it specifically excludes RIFs from its jurisdictional scheme, and I'm looking at 5 U.S.C. 7512B. In the cases talking about CSRA exclusivity, talk about it in terms of remedies for aggrieved employees, and as you know, a RIF isn't really just getting rid of an employee, it's actually excising a position from the agency. And I actually think OPM has a pending rule that would remove RIFs entirely from MSPB jurisdiction. So it seems odd to lead with a channeling claim where It's a little unclear, at least to me, whether that claim.
So I take your question, Judge Pillard, to go to the question of whether, in general, challenges to a RIF have to be channeled to MSPB pursuant to the CSRA scheme. So the first thing I note about that is the plaintiffs haven't made that argument. They haven't said, in general, RIFs aren't channeled. Their arguments are focused on RIFs done for this particular reason as part of an agency shutdown. So I don't think the court needs to resolve that question here, but the fact of the matter is today, notwithstanding the proposed OPM rule, today there is by regulation MSPB jurisdiction to consider a RIF. And I take the lesson of Elgin, the Supreme Court's decision in Elgin, to be that where the MSPB has jurisdiction, with one exception in the statute, that's for discrimination claims that can be brought, for example, under Title VII. With one exception, where the MSPB has jurisdiction, that jurisdiction is exclusive. And so I do think that channeling is dispositive of that. Even if you think there was a final agency action that was a shutdown decision, I think the MSPB still has exclusive jurisdiction that precludes a court exercising authority under the APA or under an equitable constitutional claim from reinstating employees who have been terminated or enjoining the future termination of employees.
Why is that if the claim is that there's a factual finding that the administration was going to close down this agency? And why wouldn't a preliminary injunction preventing RIFs address that, even aside from individual claims of employees?
So I take
The
this
RIF
to
was
be,
for 90% of the, am I correct? Like there was a plan to RIF 90% of the employees. So it seems that
there
that is
was at one
responsive
point-
to the claim that the agency was going to be shut down.
there was at one point a plan to RIF somewhere between 80 and 90% of the employees. But I take this to be the point of the controlling opinion for the Supreme Court in the NIH case that Justice Barrett authored, which is even if you have an APA claim challenging final agency action, if you have a channeling regime, in that case, it was the Tucker Act regime that channeled contract claims to the Court of Federal Claims. Here it's the CSRA that channels employment claims to the MSPB. If you have one of those channeling schemes, you can't, as an APA remedy, get the sort of relief that lies within the exclusive jurisdiction of the body to which Congress has channeled the claim. And so here, the MSPB has exclusive jurisdiction over the reinstatement of employees.
So are you saying that district courts can't enjoin the firing of employees ever, because that's only relief that you can get from the Court of Federal Claims?
I think that is correct, with the one exception that the court mentioned in Elgin and drew an inference from that. The court said in Elgin, Congress was careful and it knew how to carve out an exception and give federal courts, preserve federal court jurisdiction over claims that go to the removal of employees. It did that in one instance. And the inference the court drew from that is everywhere else, MSPB jurisdiction is exclusive.
So how would this work if the district court found that in fact the administration was dismantling an agency and one of the things it was doing was riffing 90% of the workforce? The district court couldn't address and enjoin the RIF?
That is my view, Judge Pan, that is simply outside the jurisdiction of the district court. And it doesn't mean there's no remedy. There is a remedy. The plaintiffs can go to the MSPB, and the MSPB, for example, has mechanisms whereby it can, on motion of the special counsel, it can get preliminary relief, as you may remember in the Harris versus Besant case.
Seems
Kathy
to really
Harris.
tie the district court's hands, like in the face of a finding that the agency is being shut down and by riffing, just for my hypothetical 90%, let's say it's 100% of the workforce, you'd say the district court would be powerless to remedy that.
I do think that is outside of the district court's jurisdiction.
Mr. MacArthur, is your argument in part related to which plaintiffs have standing? So on your view, only the employees could get an injunction about the RIFs, which suggests that the claims that, for instance, the panel, the parties with standing that were found by the panel, the NAACP and Mr. Steig, they could not get an injunction with regard to the RIFs. That seems to be an unstated premise of your argument.
That is my view. I hadn't viewed it, Judge Rao, as a standing issue. I view it as part and parcel of CSRA preclusion.
Well, it's CSRA preclusion, but if the plaintiffs that have standing, for instance, asserted claims that implicated the RIFs,
then perhaps to Judge Pan's question, maybe the district court would have some authority over that. I mean, does your claim turn on who is able to bring these types of claims? I mean, on your view, like the employees are channeled out by the CSRA. I take that point. But what about the remaining plaintiffs? I think you also then have to have some argument about why whatever plaintiffs have standing can't get the RIF injunction.
I think this comes back to my answer to Judge Katsas's question earlier. My view about CSRA preclusion is it's not a party-specific inquiry, it's a claim-specific inquiry. And so any party, whether an employee or an association representing employees or an entity that is a consumer of government services, that is asserting a challenge to an employment action, that claim has to be channeled through the scheme that Congress set up in the CSRA. And that means if that scheme doesn't offer a particular party a remedy in that scheme, it means they're out of luck, which is what this court has said repeatedly, that what you get under the CSRA is what you get. And that's, for example, what the Supreme Court held in
We haven't
Fausto.
said that.
The RIF is being challenged by not an employee, but by a party that is otherwise harmed by the shutdown. So if a party is challenging the shutdown, who is not an employee, but they're suggesting that having, large scale RIFs is affecting their rights.
So that's a case like the
And
Supreme
that's not
Court's-
about channeling that.
I still think that is about channeling. That's
Yeah.
cases like the Supreme Court's decision in Block versus Community Nutrition Institute, where the courts draw an inference that if Congress sets up a comprehensive integrated scheme for review of particular type of action, and it provides certain people remedies in that scheme and other parties get no remedy, the inference is the parties that got no remedy in that scheme, it's not that they get to go to federal district court, it means that they have no remedy. Otherwise, we would have to assume that Congress set up a scheme where if there's, for example, a RIF, that means that consumers of government services who say this RIF is going to cause injury to me by disabling the agency or downgrading the quality of the services that I consume, that would mean that parties throughout the country and federal district courts across the country could bring challenges to the same employment action and get conflicting decisions. And that is precisely what Congress was trying to avoid when it set up the exclusive CSRA review scheme for employment actions and said those claims have to go to the MSPB and from there to the federal circuit.
I take it that you're sort of jumping ahead of the question of the cause of action. If you disagree with this, but if we were to affirm the district court's finding that there was a decision made to shut down the agency and it was on a rush basis being executed, and as the panel found, if the full court were to agree that there are people who sought services and were expecting services from the Bureau that were harmed, as I take even the cases that you cited, if the violation is organization-wide or system-wide, then it's appropriate to have organization-wide relief. And for people deprived of services, that would be to set aside the shutdown decision. And I guess I'm trying to understand what your response to that is. It's not that the people seeking services, the plaintiffs who the panel agreed had standing, are challenging the RIF. They're challenging the shutdown, which has a bunch of different steps that were involved in implementing it. But the decision that they're challenging is the shutdown. And I'd just like to, it feels like you jumped over that and got into talking
Well,
about the RIF.
I jumped over it because CSRA preclusion is jurisdictional.
Yes.
And my point about CSRA preclusion is even if you assume all that, even if you assume there was a final shutdown decision that is a reviewable final agency action under the APA, of course we dispute all that, but even if you assume all that and assume the court can vacate the shutdown decision, it does not follow that the court has the equitable authority to enter an injunction reinstating employees or prohibiting their termination. That is exactly what happened in NIH. Their agency had issued guidance that said, here's the guidance that's going to govern termination of DEI grants. And then the agency went forward and terminated a bunch of DEI grants. And when that went up on our stay motion to the Supreme Court, Justice Barrett in her controlling opinion for the court, said the APA challenge to the guidance can be heard by the federal district court. But even if you can review that final agency action and set it aside, there is no jurisdiction in the district court to reinstate the grants, because jurisdiction over grant terminations has been channeled to a separate body. So I think that same logic applies equally here.
So you're just saying, okay, even if, and I take it you're not conceding, but you're just structuring the way you're thinking about it. You're saying, even assuming that the plaintiffs that we found had standing are entitled to some relief, it would have to be carved out of that relief that the agency, part of shutting down the agency is that it will be bereft of employees.
That's correct. Any remedy that goes to the removal of employees would have to be carved out of any injunctive relief in the case.
To me, that sounds more like an argument about remedial discretion on the back end than about channeling on the front end. But is there any practical difference, or is that just kind of a lawn or egghead quibble that we don't need to worry about too much?
I will say I don't find Justice Barrett's opinion precisely pellucid on that point, whether it's a claim or remedy related point that she was making, but what she says is you can't, a federal court exercising APA jurisdiction can't end run the scheme by granting injunctive relief that has the effect of reinstating terminated grants. And I think it's the same exact logic here. You can't end run the CSRA scheme through the APA by reinstating employees as an APA remedy.
Would that extend to the extent you have third parties, so not employees, bringing claims that they're in need of services from the government, they're legally entitled to them. Let's assume for this question, statutorily mandated services. They can only be provided by human beings. And the court not make an order with respect to specific individuals, but order the government to ensure X, Y, and Z positions are staffed, and any actions that would preclude keeping those positions, mandatory ones for this purpose, staffed.
I don't think so, Judge Millett. I mean, that still sounds to me like you're exercising jurisdiction over the removal of employees. I think what.
No, I'm just, it's the maintenance of a statutorily mandated office.
I don't
What's your
know.
best case, I guess, for reading it that broadly? This is nothing like Elgin.
I think NIH, Justice Barrett's controlling opinion, NIH is the key opinion on this point. But I don't.
It doesn't look, this case is nothing remotely like that. The order I'm envisioning is nothing remotely like that. I mean, what you want us to hold is that the CSRA has tentacles that reach across the entire litigation system that prevent courts from even ordering the government to comply with the Constitution by keeping functioning the offices that Congress has created and funded. And that that may be your position, and that's fine. I just want to make clear that is your position. And two, do you have any authority that reads it that broadly? And the NIH decision by Justice Barrett, it doesn't come remotely touch this.
So
nor do the other cases you've mentioned so far.
I'm not certain how CSRA preclusion would work in that hypothetical, if I understand it correctly. What
Okay,
we're
I thought you
positing,
said it would apply, but
well, I just want to make sure I understand.
Okay.
What we're positing is an order that's not about the termination of any particular employee,
exactly.
but simply an order that says
Keep an office staffed.
someone has to be there.
Maybe you'll have AI in a few years, but for
Okay.
now, let's assume it has to be human
Yeah,
beings.
I'm not aware of any precedent on that issue, and it's not clear to me that would be a CSRA issue, but I don't know why a court would need to get to that level of saying you have to have a person staffing this as opposed to you have to provide the service. That's the typical remedy that you would get, for example, in an action under APA.
But an order that
7061.
said, I mean, you're just, you can flip word games around here, but an order that says you must provide this service, and let's assume for these purposes that there have to be humans there to provide it. It's not entirely computerized. So humans have to be there, and those humans must work for the agency to do it. Then
Well,
It
they
feels
don't
like-
necessarily have to work for the agency in an employment capacity. The agency could hire a contractor to do that service. That's getting into sort of the executive branch's discretion to figure out how to perform.
Volunteers, obviously, that's a problem. So, right, so.
Right, no volunteers, but that's trenching on the executive branch's discretion to determine how to perform the statutory duty. I think the court's role is at an
If you
end.
have that
once it-
contracting authority, but yes. But, so your view is that so it's just a phraseology question, that the court can order you to ensure that there are human beings there that work for the agency to provide these services as needed to remedy a third-party claim.
I suppose that's encompassed in the idea that the court can order you to provide a service that's statutorily required and that you have withheld, that there must be some way, whether it's a human being or AI, I don't know, some way to perform that service. I just don't know why a court would need to get into that level of granularity about how the service is performed when what matters to the plaintiff is, do they get the service? And so the court can simply order the agency to provide the service that has been unlawfully withheld.
And what's
What- Just to play this out, let's suppose that that's the order, provide the service. And then the allegation is that the government is not providing the service because it fired all the people or riffed all the people who provided that service and hasn't rehired anyone or hired contractors or anything else. And the plaintiffs come back. Are you saying that at that point, the court still couldn't order the government to hire people or rehire people? It would just have to say again, you got to provide the service because of channeling.
Yeah, I guess I haven't thought about how that would play out, Judge Wilkins, in the context of an order enforcing a court order to provide the service that has been disregarded. I don't know whether that would be channeled through the CSRA's scheme. I don't
Why
know.
would it be any different? I mean, if you're saying that the court doesn't have jurisdiction to order it in the first place because of channeling, how would the court suddenly have jurisdiction to order it as
It may be that the court doesn't. It may be that that's channeled. I just don't want to take a firm position on that, not having thought through the question or seen any precedent on it. The NIH precedent is about APA jurisdiction, not about a court exercising jurisdiction to enforce.
It's not clear to me why the answer wouldn't be the same that you gave to Judge Millett, which is that if you have contractors as a possibility, then even at enforcing a prior order, it can't be that you have to hire somebody. It could be that you have to supply the function through various means, including potentially hiring somebody, but it could be that you have to provide the function through contractor.
I mean, that makes sense to me, and I suppose you can,
Possible.
imagine a recalcitrant agency that simply refuses to comply. And some point, that's the only possible remedy, and then you would be confronted with that question. But I think in the first,
I'm sorry, finish your
no,
sentence.
no, go ahead, Judge.
You're done with that, okay. If the contracting process is gonna take too long, and sometimes government contracting can, what's that, report in the interim? Say, get somebody in the seats, you have to this is a service that requires a human and human judgment, get a human in the seat. And you go, well, we're planning to contract it, we're gonna bid it out, it's gonna take us 3 months. What then? Can the court say, so I guess we just have to wait 3 months, or can it say, get people in the seat now? And that, which effectively means the only option is employees.
Perhaps in that sort of
I
circumstance.
mean, perhaps doesn't, you've got a whole channeling argument here. Is that within the jurisdiction or not?
Are we in enforcement of the court order context or the APA?
I don't know why it would
jurisdiction?
matter.
Well, I
You
think
can give two different answers, that's fine.
for the APA context, I am sticking with my answer that is outside of the court's jurisdiction under the APA, under reasoning of Justice Barrett's opinion in NIH.
Well, then there'll never be any enforcement because you'd say the injunction couldn't require that anyhow. With the injunction written, provide this service and provide this service within a week or within 3 days or 24 hours.
I mean,
Because it's statutorily mandated. You should never taken steps that stop the service in the first place.
typically in 706(1) cases, courts give the executive branch quite a bit of leeway to figure out how to provide.
Well, when I
and-
can understand sometimes when they're not going to give such leeway.
Right.
This record might be, well, be the one. I'm just asking you, could that, let's assume the government has used up all its credibility, burned its bridges. And so the court says, get this service reinstated. You got 48 hours. I'm tired of the back and forth. Get it reinstated. Do it. If everyone knows that, that means you've got to employ somebody or recall somebody, because you can't go through a bidding process on that schedule within the jurisdiction.
That strikes me as fine. If the court's saying, here's the deadline I'm giving the agency to comply with a statutory duty, and the agency is left with figuring out how to comply with that, even if it means they have to rehire employees, I don't think that would be a
We flip
CSR
it
issue.
around the other way, and the plaintiff comes in and says, the government just gave notice that it's shutting down this office completely, even though it's statutorily mandated. I'm using that service. I need that service, and I need it soon. Like I need it within the next 24 or 48 hours, or I will be, it's a health issue or something like that. And so the district court says, calls you in, the government doesn't have a plan, doesn't have contractors in the waiting room, and so says, you must keep this service turned on, and you may not take steps that result in that service being turned off going forward.
I mean, that hypothetical, I think the court would have authority to order the agency to provide the service to that plaintiff. I don't think the court even there would have the authority to go beyond remedying the discrete injury of the plaintiff before the court. And that's one of,
If the process then, sorry, just to clarify these things, I know when I cross your line, provide this service and you're enjoined from taking this plan that you announced, because it would, which say will soon include fires 100% of the people in that office, because that would preclude you from providing this service on this timeline.
I don't think you could enter an injunction that goes to the entire plan. I think the injunction has to
I
be,
don't want to get into that. I want to say that I was trying to make clear here, you have an, announced plan that says we're stopping this service, this office, and all this office does is this service. That's the only reason I'm talking about the plan. So you may not take, we're going to fire everybody, 100% of employees, shutter the place. And I assume you said it would be okay to say, no, you won't. You won't shutter the place. You won't stop providing the service. And because you can't provide that service without humans, you will not terminate whatever number those humans are required to provide that mandatory service.
so
Until you come up with another plan.
I don't think a proper injunction could say all of those things. I think it could say you must provide the service to this particular plaintiff who has come in and showed that they will have irreparable harm if they do not receive this service that has been unlawfully withheld. I think going any broader than that and saying I'm going to enter an injunction that reaches this entire plan or provides relief to other parties before the court is inconsistent with the remedial principles the Supreme Court just reinforced in CASA, which says that the equitable authority.
It's
of a-
completely tied to this individual plaintiff in my hypothetical. You don't have any CASA issue here. I need it, and I'm gonna need it on Friday. And you said you're shutting it down. You got no time to get contractors in there. Have people in the chair able to give me that service, to give this client, this plaintiff that service on Friday.
I agree there's not a CASA issue.
Is that
with
okay there?
Ordering the agency to provide that service. But going beyond that, I do think presents a CASA issue, and I do think there are serious
Going
CASA
beyond that,
issues.
how? I'm not
with-
sure. I may have misunderstood. I may have misspoken, or I might not be thinking about this right. So what about, when would it cross the line from making sure there's people, the necessary people there to provide this service on this day? What more?
If a court is entering relief that goes beyond what's necessary to provide complete relief to the party before the court who has demonstrated irreparable harm, I think that is a
If the
CASA.
only way to do that would be, you wouldn't allow the words to say, and so have employees in there. But if the only possible way to comply with the court's order is to have employees there, then it's okay? As
I
long
mean,
as it's phrased?
If it's directed at the injury of that particular plaintiff,
That's definitely my
what I'm saying, you
hypothetical.
can't say is there's this broad shutdown plan, and if they
That's
shut
not my
down,
hypothetical. I'm trying to
Okay.
keep things focused very much here on if it's phrased the way I think you want it phrased. Make sure you can provide that service to this plaintiff who needs that service. Throw CASA out for now. And you can provide that service on Friday. This is Monday. You'll be able to provide that service on Monday, and you'll have the staff there to provide that service to this plaintiff. That would be an okay order.
that seems fine to me.
So I just want to back up, because it seems like this whole line of questioning has been on the premise that the plaintiff's challenge, which is that the claim has to proceed under 706(1). So, and I understand that to be your argument, but if the claim here is a challenge to the the Bureau's action shutting down, then it's not a section 706(1) claim, it's a 706(2) claim. And it's like if the Bureau published a notice in the Federal Register and said effective immediately, we are shutting down. Employees are instructed to take all action necessary to shut down. It's, Biden versus Texas, the Remain in Mexico, halting a prior policy. I know you don't agree that that would be final agency action under 706(2), but assume we disagree with you, that it is final agency action. Then the relief would have to be matching that violation. And it wouldn't be limited to, assuring that you could provide the particular plaintiffs the relief that would respond to the injury in fact that they claim in support of their standing. It would be to remedy the violation, which is the unlawful dismantling of the agency.
So accepting for purposes of argument that there is a final agency shutdown decision that's reviewable under the APA, I think a court could vacate the shutdown decision, but you would still have a separate question about injunctive relief. And I still think even in that scenario, the injunctive relief has to be tailored both to fit the nature of the violation and to remedy the plaintiff's injuries. And the injunction here does neither of those things, because the violation, the purported violation, was shutting down the agency entirely. This injunction goes well beyond in order to keep the Bureau open, so it doesn't fit the nature of the violation, and it also goes well beyond what's necessary to remedy the particular injuries of the plaintiffs in this case.
So that's exactly what I'm curious about having you tell us more about. If I took you to be objecting in the district court and at the panel stage to a follow the law injunction, and the district court thought that that was not going to be effective in any event because there was so much disagreement about the character of what the agency was doing. The agency did and still contends that it was never shutting down, it was only downsizing. And I think the district court reasonably was exercising discretion and saying, well, I need to be more concrete then. I need to be more concrete to tell you what I mean by saying you need to not shut down the agency. So, and that there was, our panel stayed in part the district court's preliminary relief, saying you can do firings and rifts and contract terminations if the Bureau can explain how this is consistent with fulfilling the agency's statutory duties. And it didn't go so well, but my inclination would be that that is still the right project to give the executive the authority that the district court acknowledged it has, and that we definitely acknowledge that it has. So what should an order say if it's going to be anything more than a set aside and, a general urging the Bureau to keep open. If there's going to be something that's has some meat on the bones, more concrete.
So I think that is definitely not the right project. And the reason why I think it's wrong goes to one of the ways in which their lawsuit, I think, is fundamentally misconceived. And that's that they sometimes act as if they are the stewards of the agency and that they are here to protect the public interest in preventing irreparable harm to the agency.
Okay, I know
That is-
that's offensive and that it feels like, the federal court superintending the conduct of the executive branch. But again, go with me for a moment. If we assume that if we were to affirm the district court's finding that the executive did in fact intend to dismantle the agency, that changes the landscape, does it not?
Not
That
in-
the burden is then more on the government. And we're not saying that generally courts are going to always get in there, but where there's been pretty aggressive action against a congressionally mandated agency, doesn't that flip the burden and say it's okay for the court to say, give me a non-arbitrary explanation of why you think having 5 guys in a phone is going to allow you to fulfill the agency's mandate.
So I don't think this is a burden issue. I think it's a CASA issue. Plaintiffs are here to vindicate their own private interests in preventing irreparable harm to themselves.
But in CASA, each individual person has a birthright citizenship claim that's specific to them. Here, the individual plaintiffs have a claim that the action, so the footprint of the relief is really defined by the action that the district court found was unlawful. And that just puts us in a different position from CASA. And CASA recognizes that if there's, exactly that the footprint of the violation is the template for the remedy.
Maybe we just disagree about this, Judge Pillard, but I understand CASA to say it's not about the action, it's about the injury. It's about what is necessary to provide complete relief to the plaintiff that's before the court. And so the way this should have gone is the district court should have said, here are the injuries that gave rise to standing, identified which of those injuries to particular plaintiffs was sufficiently grave and irreparable to warrant the strong medicine of a preliminary injunction, and then entered an injunction that was tailored precisely to remedy that injury. And so if the only plaintiff here who had standing was the NAACP because the Bureau stopped providing education materials to the NAACP and that injured the members, then the preliminary injunction should have been tailored to redress that specific injury. The court could have said, while we're litigating this case, you must continue providing those services to the NAACP.
I don't think that that's supported by the cases that you cite, in the sense that, yes, if it's a mandamus claim under section 706(1), but for example, if an agency has statutory obligations to file reports and it doesn't file a report, and there's an organization that depends on those reports and can establish that, so we want the report, 706(1) claim. But if the agency promulgates a rule and says, we are never doing those reports again, that changes the nature of the action. And that same plaintiff doesn't have to go to court every single time and say, this report, I need it, this report under 706(1). It can go to 706(2) and say, you have to issue those reports, even if it only ever planned to use the next one and the rest of it is for other people. So I guess I'm not seeing you providing support for the notion that even a 706(2) systemic or larger footprint violation, then when you come to remedy, shrinks back down again.
Yeah, I think we may just disagree because I would answer the hypothetical differently than you did, Judge Pillard. I would say in that circumstance, there may be the APA remedy of setting aside the action that says we're no longer going to produce this report. Set aside that action. There's still a separate question about what authority the court has to enjoin the agency to do things or to refrain from doing things. And now we're in a CASA inquiry where we're looking at the scope of the equitable power of the court. And CASA says the ceiling, this is not the floor, but the ceiling is complete relief to the plaintiff. And so if the plaintiff in this hypothetical only uses one report, Any injunctive relief would have to be tailored to remedy that plaintiff's injury and say, produce a report that this plaintiff
Can I
is
clarify
injured.
your answer here? I just want to make sure I understand this. So if the court sets aside, vacates an agency decision to stop producing reports, you're saying the court can't also order the agency to actually affirmatively produce the reports? It can only order, I mean, is that right?
No, I'm not saying the court couldn't enter any injunction. What I'm saying is any injunctive relief would have to be tailored to remedy the injury of the
But
plaintiff.
but we're not setting aside little bits of the agency action. We've set aside the entire agency decision not to produce the reports.
Well, I mean, that does get into questions about what vacatur, I mean, CASA sets vacatur aside as an APA remedy and says, we'll leave that for another day, whether
Absolutely
it's divisible
does
or
not
not.
address APA.
Even assuming vacatur is sort of an indivisible remedy and you're setting,
I want to
aside-
understand how the Justice Department understands when its agency is, its action is vacated as unlawful. Its decision to not do something, a negative here, is vacated as unlawful, which means that the law still requires you to do something.
correct? I'm with you.
Does the
that far.
agency not view that vacature by itself as its obligation to produce all the statutorily required reports
I think it would have a statutory obligation to produce those reports, but that is an entirely,
for whoever asks for them?
yes, the executive has that
For the public.
statutory obligation. That is a
But
separate
nobody,
question.
but no, if I'm understanding your answer right, and please correct me if I'm wrong, your view is, but ain't nobody can make you do it. We have to have 3 million people each file their own lawsuits for their reports to get it done. Is that your view? No court can order you to do it unless they happen to have 3 million plaintiffs in front of them.
If a court does not have a plaintiff before it who's injured by the failure to produce a specific report.
That's a nice way of saying, I think the answer to my question is yes,
I-
no one can make you do it. We've set aside, we've said it's unlawful. So what? You can't make us do it.
That is the core lesson of CASA.
So
where the-
I'm just going back. I mean,
Might be why it doesn't apply to APA cases. Which I think has
It
been
applies
said by
to-
some
it applies to
justices.
injunctive relief in APA cases. It applies to injunctive relief anywhere. And what the court said there is, yes, the executive always has an obligation to follow the law, but courts do not have unbridled authority to enforce that obligation. In fact, sometimes the law prohibits courts from enforcing that obligation. That is what the court held, that your equitable power is limited to providing complete relief to the parties before the court, even if there's unlawful action going on somewhere else that maybe some other party who's injured by that hasn't brought a claim that's before the court.
Does CASA
So
even
in-
apply to APA cases? Was that question left unanswered?
I think CASA applies to injunctive relief whenever it's entered. The court set aside the question of the APA remedies of vacatur and says, we'll leave that for another day. But it was dealing specifically with injunctions, and it was a preliminary injunction case like this one. And the court said your relief is limited to redressing the injuries of the parties. before the
APA injunctions don't arise under the APA, not the Judiciary Act, which is what was construed in that case. What is your best authority that either the text of the APA or historical practice at the time of the APA, so early agency review practice, so constrained agency orders,
I don't,
court orders to agencies after vacature to comply with the law?
I don't know. I don't have a case at my fingertips.
Well, then
Judge
I don't know
Millett, but
how you can just assume CASA applies there because it was interpreting a specific statute, the Judiciary Act. And its historical, very ancient applications. And it made clear that's how we analyze these issues. And so we need to look at the APA and the practice at that time. And I believe that the practice at that time allowed such relief.
I mean, if you're talking about a
By
specific
federal-
remedy that the APA grants, like vacatur, I think that's the analysis. But
I'm
the APA was-
talking about the ability to enter orders, declaratory or injunctive, if necessary, to enforce the vacatur relief.
I think the APA just incorporates the background equitable principles.
On what basis? as opposed to the practice at the time the APA was enacted.
That's my understanding of how the APA equitable authority works, that it's not granting some new and different.
Okay,
kind
but if
of
the history in fact were different with agency review, say, early 20th century, late 19th century, then it would be a different answer.
Mr. MacArthur, are you aware of any
Sorry,
authority?
I'm sorry, that would be a different answer.
What would be a different answer?
It'd be a different answer, CASA wouldn't apply then. CASA is about statutory construction.
But CASA is construing the scope of a court's equitable authority, and I think
Under the
it's that
Judiciary
same-
Act, under a specific statute.
I think
And
that
if a
is
different
correct.
statute had a different history, different answer.
It's at least, I suppose, conceivable, but my
I
understanding
think that's how it
is that-
works. I mean, do
is
you
it-
think the court would do a different type of analysis for reviewing this question of the APA than it did in CASA for reviewing it on the Judiciary Act? I think it would follow the same model. What did Congress intend?
I think it ultimately would be a question of congressional intent, and my understanding is that APA left equitable remedies where it found them. It didn't, and
And that understanding is based on,
that's my understanding of the APA. This is not an issue that has been explored in the briefing here. We'd be happy to submit supplemental briefs on it if that would
I'm
be
just wondering,
useful to the court.
you just seem to assume, I mean, you've made a lot of arguments about how it applies to all injunctive relief, and that's why I was wondering.
I mean, I think
What
this
your
is,
basis for that was.
I think this is simply a basic equitable principle that even predates CASA. The Supreme Court's cases have always said that an equitable remedy has to be tailored to the injury of the plaintiff.
You always said that in APA cases.
I'd have to go.
So I just want to,
Judge Rao?
Oh, yeah, I was, so whether or not the reasoning of CASA applies to the APA, I mean, here, as you say, we're reviewing a preliminary injunction. Does this court have any authority to uphold the preliminary injunction as APA vacatur or stay?
I don't think so. That was
I
not.
mean,
the remedy
that would be the relevant inquiry then. That's, I mean, we can't substitute a preliminary injunction with an APA stay, can we? I'm not aware of any authority.
I'm
by
not
which we
aware
could
of
do such
any
a thing.
authority for that. That was not, the district court didn't purport to exercise like 705 authority here to stay the
So
effective
the
day.
question of whether this applies under the APA isn't really one for this court.
Well, I take the point of Judge Millett's questions to be whether the same equitable principles that govern injunctions in other contexts also apply to injunctions entered on the back of a finding of a violation of the APA. I think that they do. I think these are general principles that apply in equity that the Supreme Court has articulated in cases long predating CASA and recently reiterated in CASA.
Can I
So-
just ask a specific question, make sure I understand how you think the analysis works. Let's suppose the statute requires the agency to provide a specific service, and the agency has had 100 people employed to provide that service. And there is a plaintiff who sues and says, they have announced that they're going to RIF every single one of those 100 people. So there will be no one to provide this service, and I want an injunction. And the court says, okay, I'm going to grant you your injunction. You would say that the most that the court could do would be to say, provide that service. And the court couldn't even say, you have to, if you're going to RIF, you have to at least not RIF all 100, so that there's somebody there to provide this service for this plaintiff. Or are you saying that the court couldn't even say that? All the court can say is provide that service.
I think the latter. I don't think the court has any jurisdiction over the RIF. I think that claim has to be channeled to the MSPB. The court could order the agency to provide a specific service that has been unlawfully withheld. And if they had to cancel the RIF in order to do it, they might have to cancel the RIF in order to do it, to comply with the court's order. But that's separate from actually enjoining the RIF. Maybe they don't need to enjoin the RIF to provide the service. Maybe they can do it through a contract or in some other fashion.
So if the court injunction said, provide that service and you can riff 99 people, but you can't riff all 100 because you need at least one to provide this service for this one plaintiff. You're saying that that would be an unlawful injunction.
I do think the court lacks jurisdiction to do that because a challenge to the RIF gets channeled to the MSPB under the CSRA scheme.
So can I ask, in this case, I see the claim as being the administration is shutting down an agency. And the plaintiffs are saying we're being harmed by the shutting down of the entire agency. And so enjoining the shutdown of the agency gives complete relief to the parties before the court, saying you're shutting down the whole agency. And part of how they're shutting down the whole agency is they are planning a RIF of 90% of the employees. And they're asking for an injunction of various things that shut down the agency, including the RIF. And it just seems to me that when you look at the actual claim that's being brought and the relief that's given, it is well matched. And the Court of Federal Claims can't give an injunction. They would have to wait until the employees are all fired and then try to get reinstated. But what's being asked for is stop the shutting down of this agency so that we can, in a preliminary injunction, so we can litigate whether all this is lawful or not. And so for the time being, don't let them RIF all the employees who do the agency's work. So I don't see why that claim, as it's before the court, can't be addressed by this injunction. And I don't see how the Court of Federal Claims is in charge of giving injunctions for RIFs, because I don't think they can do that, can they?
The MSPB can grant preliminary relief in certain cases.
I'm sorry, MSPB.
Yeah.
I was thinking of this morning's case.
I understood. They can grant preliminary relief on motion of the special counsel, and even if there is no such motion, they can
So the
expedite review.
MSPB can enjoin an entire agency from riffing its entire workforce where the claim is that you're shutting down the whole agency and it's a separation of powers claim. Is that properly before the MSPB?
That's my understanding, if it's done on the motion of the special counsel, that they can enter preliminary relief. Even if they don't do preliminary relief, they could do expedited proceedings. And even if they do none of that, there is a remedy that is fully adequate to employment harms on the back end, reinstatement and back pay. And that includes, if they determine that the RIF was without a bona fide lawful basis, unwinding the RIF and reinstating those employees to their former positions.
But you would agree that this is not the typical case that gets sent to the MSPB. Like there's a claim that the entire agency is being shut down, which includes RIFs of 90% of the employees.
Yeah,
That
this case
sounds
is,
very much like something that should be before a district court and not the MSPB. You don't think so?
I think this case is atypical in many respects, but I don't think that negates CSRA preclusion. That is exactly the argument that the Supreme Court rejected in Elgin, where the plaintiff came in and said, I've got a constitutional bill of attainder and equal protection claim. This is nothing like the ordinary workaday merit system protection principle cases at the MSPB.
But what
hears.
about Axon? Is this more like Axon? Like where you're challenging bigger things and the institution itself?
No, I know the plaintiffs point to Axon, but Axon left CSRA preclusion where it was. It had nothing to do with CSRA preclusion. It specifically distinguished Elgin and said Elgin is the case that governs removal of employees. And that is squarely what Elgin holds, that the MSPB has exclusive jurisdiction over claims relating to the removal of employees. It does not matter why. It does not matter what the reason is, whether this is the result of an unconstitutional statute, or here the claim is it's the result of an unlawful or unconstitutional closure of the agency. We're not looking at the reason for the removal. We're looking at the nature of the action taken. And that's what triggers the MSPB review scheme. So if you're
Let's-
talking about removal of employees, it must go.
What if you've got some employees who are about to be riffed or have been riffed? And they're entitled to due process, which is what Congress is providing through the CSRA normally. But if the riffs are part of, I understand there's a debate in this case, so for hypothetical case, or assume that there is in fact a concrete, written down, fully announced, published in the Federal Register, we are shutting down this agency and it will be shut down in 2 months. Okay? And the employees, they start getting fired. They have to go get their due process from the MSPB or maybe FLRA. And the court has before it an action like this with a variety of plaintiffs complaining about challenging the decision to shut down the agency. Could a district court prevent shutdown of the agency solely so that the MSPB would have the capacity to provide process and relief to these individuals who cannot be reinstated once the agency is abolished? This is not like abolishing a single position or a single office. The entire agency will be gone. So we're just halting the shutdown, at least of the offices from which these employees, in which they work, to ensure that if relief is ordered, they can be reinstated.
I'm having difficulty envisioning exactly what that order would say or look like, Judge Millett. Would it just be there, you have to keep a director of the CFPB so that when the MSPB
These
grants
offices,
relief,
whatever
there will be-
statutorily mandated, it has to exist so that those who are wrongfully terminated will have a place to go back, so that relief can be given. I don't know what relief can be given to people if the agency's gonna be gone before they can even get their ALJ hearing
I'm not,
at the
I
MSPB.
guess I'm not sure what it means for the agency to be gone. I mean, as long as there's still an acting director
I
there.
mean, if you want to fight the hypothetical, fight the hypothetical, but I'm telling you that
I'm not
the
trying to
court's
fight
going, okay, the court's, however, the court has got to, can the court issue some order that ensures there will be an agency to which these employees could be returned if unlawfully terminated or rifted?
I think likely so, but I'm not sure why that would go beyond something very limited, like you have to keep a director, because if the MSPB is granting relief, I think that relief would look something like an
That's a
order to.
tailoring issue, but not a power issue. I'm just raising the power question, the authority question. If it's necessary to ensure that relief could be afforded to these people, they have time to pursue their remedies.
Yeah, if that sort of relief is necessary to remedy the injuries of the plaintiffs before the court, and I don't take it that would be talking about the removal of specific employees. I don't think that would
I'm
be.
talking about the employees too, who wouldn't have time to even, like I said, to even get before an ALJ over at the MSPB, let alone have the case adjudicated and go up through all the different levels to get reinstated. I mean, it just seems to me that if the concern is that channeled, the process to which they're being channeled will not be able to function because their agency is getting abolished. And all this is assuming that's unlawful, which, you know, there's debates about that. You can argue that. But there'll be no capacity for them to get due process, any relief, unless there is an agency for them to go back to and be reinstated.
I mean, the MSPB, if it determines that the RIF is unlawful, it can unwind it and say, you must reinstate these employees to their former positions. And as long as there is a you to whom that order
Well,
can
you
be
said,
addressed.
I want to be crystal clear here. I assume an individual employee can't bring that claim. You said the special counsel would have to bring that claim.
No, I think the special counsel is just about preliminary relief. Absolutely, individual employees can bring a challenge to a RIF before the MSPB, and the RIF can assess whether that was, there was.
I understand, but if by the point, I guess my question is, by the time they get before an ALJ, let alone the board itself, the agency is going to be gone. Under my hypothetical, the agency is going to be gone.
What do you mean by the agency is gone? Do you mean
The
there's no
agency is
longer-
going to be gone. That's what the memo is that I hypothesized for you. We are abolishing the agency. I leave it what the president decides he wants to do with the person in that was acting in that position. It's going to be gone. Right?
Means there's no longer any director of the agency.
I'm just telling, yes, it's going to be gone. That was my final agency action, my memo, written clear as could be, published in the Federal Register. It's going to be gone. All right, all kinds of problems with that.
Okay.
Can this, for the employees, for the individual, the plaintiffs who are channeled to the CSRA, can the district court enjoin the complete abolition of this agency? I'm not here to talk about the tailoring, what that has to look like, in whatever way, shape, or form, in some way, shape, or form. Preclude that so that there could be a remedy available for these plaintiffs.
It's not a question I thought deeply about. It seems to me the answer is likely yes, that the court could do whatever minimal action is necessary to ensure that there's still a director there to whom
I'm
the
leaving
MSPB could issue an order saying reinstate
aside the
these
tailoring at
employees.
this point, yes, but what that would entail. Okay, thank you.
Can I
On-
just,
Go ahead.
move to the constitutional claim? So you started out your presentation saying that there was no shutdown decision and the agency, and the president does not contend that there is authority to shut down the agency or cease its operation. The district court made a finding otherwise, that there was such a decision that had been made. Is it your understanding that we review that ruling finding as a finding of fact by the clearly erroneous standard, or do you have a different way we should look at that issue?
I mean, I think it depends on for which issue in the case you're analyzing this putative decision. If you're asking the question, was it a final agency action?
No, I'm talking about the constitutional claim that this violates separation of power.
Right. So we have our argument under Dalton that this isn't a bona fide constitutional question, that it is the claim premised on the violation of statutes, and therefore there is no equitable constitutional claim. I'll bracket that for a moment. And if you say there is an equitable constitutional claim, then yes, I think you would be reviewing that decision, the district court's finding that there was such a decision by the president or the agency head or whoever the district court found made the decision, which isn't entirely clear. You would analyze that under the clear error standard. Now, we think the district court committed some threshold legal errors here that mean that even the clear error standard doesn't apply. For example, the district court failed entirely to apply the presumption of regularity that should govern review of executive actions. And when a district court makes findings under an incorrect legal standard or under a misapprehension of applicable legal principles, the clear error standard doesn't apply. So we have that argument. And if you got past that and rejected that argument, then I think we're doing a constitutional claim. You would be looking at whether that decision was clearly erroneous. And even under that standard, we think that it was clearly erroneous because there's no fair reading of this record as a whole that supports the conclusion that the acting director had made a decision at any point in early February or thereafter to entirely close the agency and cease performing its mandatory statutory duties. There is simply too much evidence, starting from February 10th itself and thereafter, of the agency leadership, the acting director and the chief legal officer, Mark Paoletta, repeatedly taking actions to ensure that statutory duties were performed, and I've yet to hear a credible explanation of why you would do that if you are acting on orders to close down the agency entirely and cease performing those duties.
So I take that point, and let's put the Dalton issue to the side for a moment. So if the court were to say, well, we don't think that that finding was clearly wrong, to go back to what we've been discussing as far as remedy goes, if we say, okay, we don't think that that's clearly erroneous, and just for the sake of this question, we don't think that there's a Dalton problem with proceeding towards deciding the separation of powers claim, and we find that there is at least a likelihood of success on the merits of a separation of powers cause of action. How does it work with respect to your view of remedy or scope of relief? Because if the constitutional violation is shutting down the agency when the executive doesn't have that authority, how does, even under your view of CASA and related precedent, how does it work as far as determining, well, what is the scope of the injunction? If the injunction is you cannot shut down the agency, your argument's the same. You still can't have, I guess it's prong 3 of the preliminary injunction, even if we find likelihood of success on the merits on the constitutional claim. I'm trying to understand that.
Right, so that doesn't change my answer at all. Scope of the remedy, what the nature of the violation is, whether it's constitutional, APA, if you're entering an injunction, has to comply with the complete relief to the parties. And again, that's a ceiling. It's not just any remedy that provides complete relief. If you ordered them not to shut down and do all the things that this injunction requires, maybe that provides complete relief, but the problem is it goes beyond what's necessary to provide complete relief. So I think CASA and the equitable principles that say you have to match the injunction to the injury that brought the plaintiff into court in the first place and is irreparable. I don't think that depends on what the basis for finding a violation in the first place is.
So as far as Dalton goes, there's a finding that the executive did make the decision to shut down this agency. And there's no claim by the executive. I mean, the executive is saying, well, we didn't really, that's not what happened, but let's assume for the sake of this question that we don't find that finding to be clearly erroneous. Then aren't we in a situation where the executive appears to have taken an action not relying on a statute at all, because they're not referring to any statute. And so there's no kind of statutory basis for their argument or no statute that we have to construe. Why isn't that outside of Dalton?
Because there is no constitutional dispute in this case. What I understand Dalton to hold is if the alleged constitutional violation is premised on claimed violation of statutes, that is not a constitutional claim that can be brought in equity. And the Dalton question is not constitutional claim or nothing. It's constitutional claim for the non-statutory ultra vires cause of action, which the plaintiffs have abandoned here, but that is a remedy that would be available for some of the more extreme hypotheticals we've heard about, for example, an agency doing something that they just concede they lack any constitutional or statutory authority for. That sounds like you'd have a pretty good ultra vires claim for that. The issue would be whether there's an adequate alternative remedy. And if there is an adequate alternative remedy, then by definition, the claim won't evade review. And if there isn't, you've got an ultra vires claim. But I think Dalton is pretty clear, especially if you look at footnote 6. Footnote 6 says in cases where the executive concedes either explicitly or implicitly that the only source of authority is statutory and isn't invoking independent constitutional authority like the president did in Youngstown, the court said there is no constitutional question whatever.
But here we don't have that. Here we have the government disclaiming statutory and constitutional authority to shut down. So the position of the government is we have no statutory authority. So there's no need, as there was under Dalton, to worry about, well, we need to construe the statute to determine whether there's a violation or there's an end run around some limitation. The reason that Dalton is there is really to protect the role of Congress in defining what remedies are available, its block, and to prevent where Congress has made a determination, you can challenge a shutdown, but you have to do X, Y, and Z, that the constitutional claim not be used to end run that. But here we don't have that because it's the difference between in excess of statutory authority, where Dalton says, it's a statutory claim, and in the absence of, which is Youngstown. And, you can say that, well, those really meld, but they don't. That's the line that's drawn by Dalton on the one hand in excess and Youngstown on the other, no statutory authority. And we're in Youngstown land in part because the government has appropriately conceded an absence of statutory authority to shut down the agency. We don't have any worry about end run.
So I disagree with that analysis, Judge Pillard. You won't be surprised to hear.
But I'm
The-
happy to hear your analysis.
The paragraph that talks about an absence of authority in Dalton, when it's talking about Youngstown, it's that same paragraph. It couples both ideas. An absence of authority coupled with an assertion of constitutional authority. That's what creates a constitutional dispute, because you have to decide what the Constitution means. This distinction between excess of authority on the one hand and absence of authority on the other, I think is entirely illusory, and it strikes me as very similar to the distinction that the Supreme Court rejected in
So-
a
so
slightly
the-
different
so the
context in
case
City
would
of
be-
Arlington.
So the case would be different if the president says, I'm shutting down, I'm ordering the shutdown of this agency because I believe that's within my authority under the take care clause. So that is a Dalton claim. I'm sorry, a claim that's not, that can be brought. But if the president doesn't utter those words and just is thinking that and says, I'm shutting down the agency and doesn't cite any statutory basis, then that case is covered by footnote 6 of Dalton and can't be brought.
That analysis strikes me as correct, and also if the executive doesn't assert constitutional authority as a defense in litigation and create a constitutional
So,
dispute.
so
about
it
that.
all is based on magic words.
I don't think it's based on magic words. I think the question is, look at what we're fighting about in the case. Are we fighting about a question of compliance with statutes? Or are we fighting about a question of what the Constitution means?
I think we're fighting about the question whether, we're not fighting about the meaning of a statute because we all agree.
I agree, it's not the meaning.
This statute does not authorize, unlike the base closing statute at issue in Dalton, under any condition, it does not authorize the executive to shut down the CFPB. So we're not in the question of excess of authority, we're in the question of no statutory authority. And I'm just not seeing how that triggers the Dalton concern, because the executive branch hasn't invoked any statute. There's no limited right of action under a statute that is being end run. It is, and the fact that the government also isn't claiming constitutional authority shouldn't distinguish this case from Youngstown, because that just makes the constitutional claim on its merits open and shut.
I agree that the dispute in this case is not about the meaning of statutes.
Right.
But it is still about compliance with statutes. It is a factual dispute about whether the statutes are being complied with. There
But
is
once you
no,
resolve that, and the statute's not being, the statute doesn't tell you one way or another. It's like either it's on or it's off. Nothing about the statute guides that determination, does it?
yes, when you open the statute, you see that it does not confer the authority to close down the agency
Exactly.
entirely.
There's
And
no
instead-
authority. Go ahead.
But it's still predicated entirely on a violation of the statute. For example,
Can I ask this question as a follow-on to what the Pillar asked? So suppose that I agree with you, just hypothetically, that I agree with you, it's hard to draw a distinction between absence of authority and excess of authority. I take your point on that with Arlington and everything, and that either works or it doesn't. But let's just assume I agree with you on that. But part of Judge Pillard's question was also, this case is different because the government isn't even asserting that it has the authority, either under the statute or the Constitution, to do the thing that the plaintiffs allege was done, which is to shut down the agency. And so if you just bracket away the excess or absence, if you just say, well, this case is really about a situation in which the government just isn't defending that it can do that thing. So it's not defending it under the statute, it's not defending it under the Constitution. Well, then in that situation, what's the point of the Dalton move to prevent the taking of a statutory claim and converting it into a constitutional claim? Because the government just isn't saying you can do it at all. So for that reason alone, is that a basis for saying the Dalton move that we need to be concerned about, which is we can't allow the bringing of a constitutional claim in a situation in which a statutory claim ought to be what governs. That just doesn't apply in a context in which the government isn't defending it under the statute, the thing that's being challenged, or the Constitution.
I think the same reasons that caused the court to say we're not going to eviscerate the distinction between ultra vires and constitutional claims and broaden the latter beyond all recognition in cases where what you're fighting about is the meaning of the statute, apply to cases where the dispute is whether factually you are complying with the statute. You don't get to any constitutional issue of saying this disregards separation of powers principles unless you first conclude in this case, you are violating the statute. You are doing something that the statute does not authorize you to do. For example, statute expressly authorizes the director to set the number of employees that the Bureau will have. Plaintiffs, I think one take on their claim could be, well, that does not authorize you to set the number at 0. I would agree with that. Statute doesn't authorize 0 employees because it imposes mandatory statutory duties that the agency has to perform that it's not going to get done with 0 employees. That's
do we
simply
only
a
have-
claim that you're exceeding the authority granted in the statute. It's not a true separation of powers claims where the statute just can't grant you that, like removal restrictions or a line item veto. Congress can authorize and has authorized the executive branch to close agencies. It didn't do that in this case. And so if the executive did that, it would be violating the statutes.
Right, well, it would be unauthorized by the statute. Would it be violating the statute? It would be, yeah, it would be unauthorized.
Right, and I don't think that distinction is a stable one, Judge Pillard, because agencies only have the authority that Congress confers on them.
I
So
agree.
anytime they exceed the authority that they have, they are acting in the absence of authority. And so you could
Right.
characterize,
Acting in excess is no less unlawful. Acting in violation.
it's not only no less unlawful, I think it's the same thing. If you're acting in excess, you're acting in the absence. So you can imagine, let's suppose that President Biden had called up the Secretary of Education and said, I'm hereby directing you to promulgate the student loan forgiveness plan that the Supreme Court ultimately decided was outside the authority of the agency in Biden versus Nebraska. Do we all of a sudden now have an equitable constitutional claim that can be brought to enjoin the Secretary of Education from following the president's directive because there is no authority in the statute to forgive student loans and there's no independent
But there
constitutional
was a
authority?
question, sorry, there was a question about, I mean, he thought there was authority there and, you know, maybe once the Supreme Court has spoken, that changes the landscape. Maybe that's the point you're making, but
No, I don't think it
But there
depends
is
on.
there is a distinction between absence of authority, Youngstown, and exceeding authority, Dalton. It's not that we're making that up. And yes, you can at a high level of abstraction sort of see, you know, cross a bridge and characterize one as the other, but we have to follow these two cases and I'm not ready to overrule Youngstown. So it seems to me we really are in that vicinity, but that's not the question I've been wanting to ask you since we were talking about section 7062 remedial scope. And I was looking for the footnote in Lujan, footnote 2, which, you know, now is the case where they're saying this is not a discrete action because the plaintiffs are trying to sort of weave together a whole panoply of separate actions that are happening in different places in different times and call it a plan and challenge it as one. But then the court says in footnote 2, if there is in fact some measure across the board, it can of course be challenged under the APA by a person adversely affected. And the entire land withdrawal review program, in quotes, because that's what the plaintiffs were packaging their claim as, insofar as the content of that particular action is concerned, would thereby be affected. So I take that to be saying you have APA remedy for that would be program wide. Now, I think your answer is right, set aside. You would have set aside power. But then we're now in the preliminary injunction context. And I don't think this has been brief, but there is power under the APA, under section 705, to the extent necessary to prevent irreparable injury when a case is pending. The reviewing court, quote, may issue all necessary and appropriate process to preserve status or rights pending conclusion of the proceedings. So I take the APA, I mean, I know the standard remedy is set aside, but this is a follow-on to a series of questions from Judge Millett. There is also equitable authority under the APA, and that's sort of the situation that we're in now, is if there's the footprint of the violation supports a measure across the board being affected by the relief, and we're in this posture where the court is trying to hold things steady until there's a final conclusion, why not recognize that there's preliminary injunctive power still tailored to the maintaining the existence of the agency, but there's a little more there than you were arguing when you were insisting that it has to be limited to ensuring that the individual plaintiff gets the service.
I don't think the district court here invoked section 705 or any of that remedial authority, but even if it had, I don't think it would change the analysis. Government's position is the same equitable principles that applied in CASA apply to those equitable remedies under the APA, and it still has to be party-specific relief that goes no farther than is necessary to remedy the injury of the parties before the court.
But I took Judge Millett's whole series of questions to be probing, how do we know so far as is necessary? And let's say we think that so far as is necessary is to have a functioning CFPB that is fulfilling the statutory obligations. Let's say we think that. You may disagree, but let's say we're prepared to hold that. I'm really interested in knowing what you think appropriate, narrow, like what's the minimum or the maximum you would tolerate in terms of, just honoring the executive's prerogative to downsize the agency, but also perform the statutory mandated functions. Can you write that for me? What would that look like? And I'm not going to take you to be agreeing that this is appropriate. I've heard all your arguments.
I appreciate it. I think the analysis is going to depend on which plaintiffs have standing and which injuries are irreparable. That's going to tell you what the court can issue an injunction to remedy. It will be in the nature of provide this particular statutorily mandated service to this plaintiff who has shown that they will be irreparably harmed without it pending litigation of this case.
That's just flipping back into 706.1. I mean, this is 706.2, where there is a measure across the board that has been found to be a violation in response to the individual suit. They're entitled under the legal theory that they've raised to something that will provide them full relief. And I mean, I guess to provide full relief, I mean, so you'd require an analysis of all the different interdependencies, like if the consumer hotline is at issue, what are all the different capabilities of the Bureau that feed into that?
I mean, I don't think you'd need to get into that. Like, let's suppose that it's the Virginia Poverty Law Center, I think, is the one who premised their standing on the existence of the consumer hotline. Let's suppose that they had standing in a viable cause of action and they've checked all the other boxes, and we're now at the question of what sort of preliminary injunction can we enter to preserve the status quo vis-a-vis that plaintiff. I think the injunction would say you must maintain the consumer hotline, the end. You don't have to get into how many employees or contracts or none of that. You just say, while we're litigating this case, you must continue to keep the consumer hotline live insofar as necessary to remedy the injury of the BPLC that relies on that for its organizational activities. Again, I'm not conceding. I don't think they have standing on that basis. If you got past all that, I think that's what an appropriately tailored injunction would look like.
Just, do we essentially only have Youngstown if the executive actually asserts the Constitution? In other words, that's a defense?
That is correct. I think that's what the court said in footnote 6 of Dalton, that if the executive concedes that it's not invoking constitutional authority and then the only potential source of authority is a statute, there is no constitutional question whatever raised. That is a dispute about compliance with statutes that has to comply with the separate requirements for ultra-virus claims.
And if the APA had existed at the time of Youngstown, why do you think that that court didn't refer plaintiffs to the APA for their cause of action proceeding?
Because there was a constitutional dispute in Youngstown. The president invoked authority under the Take Care Clause and Article 2 and said, regardless of any statutes, I have the independent authority to do this constitutionally. If in Youngstown, the president had simply said, I'm doing this, notwithstanding the absence of any statutory or constitutional authority, then that would be an ultra vires claim, and probably a pretty good one if there weren't an adequate alternative remedy, which on the facts of Youngstown, there probably was an APA remedy because the Secretary of Commerce had issued possessory orders to implement the president's executive order that likely would have been final agency action under the APA.
And I'm kind of asking it because plaintiffs are generally masters of their complaint. And so are we backing into essentially this defense by that assertion?
I do think it depends on the nature of the defense that the executive branch asserts. I think this goes to the footnote in the panel opinion talking about how the equitable right of action is not really cause of action because causes of action didn't exist as such in equity. What we're really talking about is there an equitable right to relief. And I think what Dalton says is if we're fighting about the meaning of the Constitution, that's the thing that can be brought free and clear of the requirements that apply to cases where we're fighting about compliance with statutes.
So I read Dalton to say that not every action in excess of statutory authority is constitutional. But I think you read Dalton to say that if it's a claim about acting in excess of statutory authority, it is never constitutional. And I'd like to sort of understand if there are any limits to your position. So what if the president issued an executive order that said, I will not comply with any statutes? Would there be a separation of powers claim, or is that a claim that he's exceeding his authority under every statute?
I think it would be the latter if he's not asserting some constitutional basis to disregard a particular statute.
So if the president says, I will not comply with any statutes, in your view, there's no separation of powers issue?
I would say that there's no separation of powers violation that can be brought as an equitable constitutional claim. What I understand Dalton to
So
say
you
is
think there
even
is a constitutional claim, but it can't be brought?
what I understand Dalton to say is even if you could think of the disregard of statutes as a species of separation of powers claim, it's not the kind that can be brought through this equitable right of action.
So you would concede, though, there's a separation of powers issue if we have an executive saying, I will never abide by any legislation passed by the legislature. That is a separation of powers problem.
I
Yes.
think there is a separation of powers concerns if the executive branch
But
disregards
it can't be
federal-
litigated in your view.
It can't be brought as an equitable constitutional claim.
Can it be
brought-
litigated at all? How can it be litigated?
It can be brought as an ultra vires claim. There are stringent requirements for ultra vires claims, one of
But
which.
why can't it be brought as a constitutional claim if it is clearly a constitutional claim as you conceded?
Because that's what Dalton says. It says we're not gonna,
Yeah, I guess what I'm trying the point I'm trying to make is that's not what Dalton says.
I do think it is, was, I mean,
Because
I
these are the
take your point.
implications of reading Dalton the way you say.
I take your point, Judge Pan, that there are some passages in Dalton where the court says not every statutory violation. But when it gets to that next paragraph where it discusses Youngstown, first sentence of the next paragraph where it sums up its holding, it's broader than that.
So,
The court says,
well, I think that's debatable too, but let's put that aside for a minute because I don't want to get into a line by line on Dalton. So what if the president said, I don't like this statute and I will not abide by it? Is that a constitutional separation of powers problem?
if the president is simply saying, I'm not going to comply with this statute because I don't like it, and not that it's
I have a
within my-
policy problem with it. I don't like it. I don't agree with it. I won't do it.
right.
that a
If
separation
there's-
of
If
powers
there's no
problem?
defense on constitutional grounds of that, then that is an ultra vires claim.
So that's also not a separation of powers claim in your view.
It's not a separation of powers claim that can be brought as an equitable constitutional claim under the Youngstown.
So
line of
how do you
cases.
reconcile that with In re Aiken County? And also, I guess, Kendall? These are cases that say presidents do not have a dispensation power. They can't pick and choose which statutes they'll execute. There's authority on this. How do you reconcile your position with those cases?
The question isn't whether the president has the power to do that. The question is which right of action applies.
Right, and those were separation of powers cases.
Perhaps so. If I remember correctly, those cases were.
They're
plaintiffs-
definitely separation of powers cases.
Well, yes, but they were, the remedy sought, I believe, in those cases was mandamus, which is its own right of action. We're talking here about whether you have an equitable, non-statutory claim that can be brought free and clear of the requirements of non-statutory ultra vires claims. That's all Dalton is
I thought
distinguishing.
we started this argument by you saying that you're not claiming the authority to shut down agencies. in violation of what Congress wants. Isn't that a concession that that's a problem, a separation of powers problem?
It would be unlawful, for sure, if the executive branch shut down the CFPB without congressional authorization to do that. But whether or not it's unlawful is a separate question from whether a cause of action exists to challenge it. And in this case, which cause of action? Is it the non-statutory ultra vires cause of action, or is it the non-statutory
I
equitable
understand,
cause of action
but-
for constitutional claims?
But your reading of Dalton leads you to take the position that a president saying, I will never execute any act of Congress is not a separation of powers problem that can be litigated.
It can be litigated through an ultra vires challenge.
Right, but it cannot be litigated as a separation of powers issue,
That is correct. That is our position.
because it sounds like a textbook case of separation of powers to me.
But it is still one that is premised on the disregard of statutes.
Okay.
And again, I want to be
But if you agree then that a president can't say, I don't like this particular statute, I disagree with it on policy grounds, I'm not going to do it. That's unlawful. A separation of powers problem. Perhaps we can't litigate it as such, but it is a separation of powers problem. Yes.
I think it is a species of separation of powers anytime
Well,
The
under
executive
Aiken
branch
and under
violates the
Kendall,
statute.
it's a separation of
or,
powers
or
problem.
disregards the statute. But the Supreme Court has said, if it's premised on violation of statutes, we have one track. If it's not, if it's a dispute about the meaning of the Constitution, we have another track.
Yes, although we do have precedents that say that it's a separation of powers problem and has been litigated as a separation of powers problem. So what is the difference between a president saying, I don't like that statute, I don't agree with it, I won't execute it because of policy concerns? What's the difference between that and a president saying, I don't think we need this agency that Congress has said we need to have, and I'm going to dismantle it? Isn't that the same thing? Isn't that another way of saying, I don't like this statute, I'm not going to do it for policy reasons?
Strikes me as the same thing. Strikes me as a disregard of a statute. The challenge that you can bring for that on a non-statutory basis is an ultra vires claim, which again, they have disavowed. This isn't a question of whether this claim is going to evade review. It's just how it gets brought.
If they had brought an ultra vires claim, what would have been your defense?
We would have said that there are adequate alternative remedies here. There are adequate alternative remedies for the employees through the CSRA scheme, and there are adequate alternative remedies for any other potentially aggrieved parties who are aggrieved by the loss of services if the agency closes through the APA.
Through section 7061.
So it would depend. If there was final agency action, then it could be under 706(2) as well. But the point is, there are adequate alternative remedies, but the court doesn't need to get into that because they haven't disputed that. They've abandoned their ultra vires claim, and they haven't even argued that these other alternative remedies are inadequate for purposes of that analysis.
To make sure my colleagues don't have.
Just one more, back to Judge Millett's hypothetical on final agency action, which I thought was a hard one in the panel opinion. So if you do have published in the Federal Register something that purports to is public facing and informally expressed and purports to be a self-executing decision to shut down the agency, that would be final agency action within the APA, correct?
I think so. This sounds
And-
like the memo that the panel opinion posited, the
Yeah, that's what,
self-executing.
you're not challenging the panel opinion saying that's final agency
We
action.
accept that.
And there would be,
That's correct.
regardless of your position on channeling the employment plaintiffs, there would surely be plaintiffs withstanding to challenge that final agency action through the
Well,
APA.
we do have some separate arguments about standing. We don't think any plaintiff here has
Okay, fair.
standing, but we do accept that that sort of immediately effective, formal,
And
self-executing
could get,
memo
and
would be
could
final
get
agency action.
set aside, at least set aside relief.
We haven't
And we
disputed that
might
you
have
could
a fight
vacate
about,
that action. If this
We
was just a
might have
case
a-
about vacating the shutdown
might have that
decision,
old fight about whether set aside means what we thought it meant or whether it means give as applied relief, but plaintiff could get relief from that.
plaintiff withstanding could get APA relief under 706(2) on that hypothetical memo.
Okay.
Thank you, Mr. MacArthur. If you care to rest your legs, you're welcome to do that. Bennett. Please proceed when you're ready.
May it please the court, Jennifer Bennett on behalf of the appellees. To this day, and as we just heard, the defendants have never disputed that they have no authority to shut down an agency that Congress created. In other words, unlike most preliminary injunction appeals, the defendants are not arguing that the conduct that the district court found they engaged in is legal. Instead, I heard, and their briefs make essentially two arguments. The first is that the district court got it wrong, that the defendants never tried to shut down the CFPB, but at the CFPB's own chief operating officer testified, that was the defendant's sole witness, the chief operating officer himself testified, without the district court's intervention, the agency would be eliminated within 30 days. That's not clear error. And the second argument, and the one that they focus on here today, is that even if the district court didn't clearly err, meaning even if the defendants took the undisputably unconstitutional action that the district court found, federal courts have no power to stop them. According to the defendants, what I just heard is what would have to happen is individual plaintiffs would have to wait until the Bureau was eliminated. They'd then have to somehow sue the non-existent agency, maybe in the MSPB, which doesn't hear claims for most of the plaintiffs at all. Neither the APA, nor the Constitution, nor the Civil Service Reform Act, nor anything else that I'm aware of requires that futile exercise. And I want to start briefly with the arguments that I heard today that are not really in the briefs that the defendants made, so that I can get those out, and then hopefully we'll move on to some of the other arguments. And I'll start with the channeling argument. So the question for channeling, I heard, the defendants are really focused on remedy. The question for channeling, as the Supreme Court said in Axon, is this the kind of claim that Congress intended to be channeled to the agency? So the question here is the claim here the kind of claim that Congress intended to go to an agency that is designed to hear ordinary individual employment disputes? And here's what the jurisdiction of the MSPB is. It has jurisdiction over agency employees' claims that the agency has violated a merit system principle. In other words, that the agency has violated the Civil Service Reform Act, the principles that govern individual employment actions. The statute does not provide any jurisdiction for non-employee plaintiffs. And as Judge Pillard pointed out, the only jurisdiction over RIFs at all is regulatory. It's through an MSPB, I think it's through an OPM regulation governing the MSPB, not statutory. And so what we'd have to think is that by saying that there is an agency that can hear individual employment actions challenging merit system principles, that Congress intended to channel fundamental questions about the separation of powers brought not only by employees or their representatives, but also brought by all sorts of other plaintiffs who cannot possibly go to that agency, whether Congress meant to channel those claims to that agency.
So essentially, these claims would be mutually exclusive.
I'm sorry, I didn't hear that.
These claims would be mutually exclusive. You've got the side of the employees who've been ripped, or perhaps consumers who couldn't continue on with their services, that they have, other remedies that they could go to. But we're not talking about that. We're talking about the entire shutdown of an agency that has failed in its statutory mandate.
I think that's exactly right, which is to say, the claim here is not I shouldn't have been laid off, or even my position shouldn't have been eliminated. It's that this agency should not have been shut down. And one of the remedies, at least preliminarily, was to enjoin a RIF so that the agency would still exist at the end of the case. But the claim isn't that this RIF violated the RIF policies. The claim is exactly that the agency would be shut down. And I heard the defendants admit that that claim can proceed in court. And so what you would have then is the same claim proceeding in front of the MSPB, which, by the way, doesn't think it has the power to hear constitutional claims, and in front of federal court. And that's exactly the problem that Elgin said we're trying to avoid. We're trying to avoid, the reason we channel claims often is to try to avoid having the same claim being heard in two different fora. And that's exactly what would happen here. I'll also,
Ms.
Can I-
Bennett, go ahead.
What's your understanding of Fausto and Elgin on the one hand, and like Axon, Thunder Basin on the other? Your argument has a lot of force if you just take the three-part test. And, you know, it has a bunch of factors. You can look to availability of relief and things like that. But if you look at the CSRA cases, I mean, Fausto says it doesn't matter if you get no relief. Elgin says it doesn't matter if it's a constitutional claim outside the heartland of MSPB expertise. Seems like those cases have a much harder edge than would be suggested just by Thunder Basin.
Yeah, so let me take them each in turn and then talk about Axon. So Fausto is a case asserting a right under the Civil Service Reform Act. And what the court said is, yes, you have that right, but Congress didn't make it judicially enforceable. And again, it was brought by an individual employee. That's quite different from a fundamental challenge to the executive trying to restructure the bureaucracy. Similarly, in Elgin, it was, it was a claim brought by an individual challenging their particular termination. And there were a couple of things that the court said in Elgin that I think are relevant here. The first is that it was just about terminations. There was no claim about restructuring the government separation of powers. And the court also says it could have been resolved potentially on other grounds. There are no other grounds to resolve this claim. The other thing that the court said in Elgin is—
sorry, I just don't recall that piece of it. What's the other ground and how does that play out?
Sorry, I'm not sure. I'll try to answer that question. If I don't give you the answer you want, let me know. So I think there are a couple of grounds in Elgin that are different. One is it's an individual employee challenging their particular termination. The second is what the court said is there may be other ways within the agency's expertise to resolve this claim. There are
within the MSPB.
Within the MSPB's expertise to resolve this claim, there are no other ways to resolve the separation of powers claim here. And in fact, the defendants concede it will go forward in court no matter what. And that's related to the third aspect of Elgin that's different here is Elgin said, we're worried about having claims about the same individual employee go forth in two different fora. And that is what would happen if you channeled here, as opposed to Elgin, where it would happen if you didn't channel. And then to go to Axon, Axon cites these cases. Axon cites CSRA cases, and Axon says they're different. And the reason they're different is because the claim in Axon goes to the structure or the very existence of an agency. And that's exactly what's happening here. This is a fundamental separation of powers claim about the structure or the very existence of an agency. And I'll note there was some discussion of NIH. I think the more relevant emergency docket order here is Trump versus the American Federation of Government Employees. And that is a case where there was a challenge to an executive order that led to some rifts, and the Supreme Court did stay the preliminary injunction in that case, but it stayed the preliminary injunction not on the basis of channeling, but on the merits, saying we think this executive order, which is very different from what's at issue here, but we think this executive order, they're not likely to succeed on the fact that it's unlawful. And which means that the court seemed to believe that it would have jurisdiction. In other words, that the claim would not be channeled. And given all of the activity on the emergency docket, the Supreme Court has not once taken up any of the channeling, the CSRA channeling challenges, and there have been several.
Ms. Bennett, if we were to assume for a moment that the government is correct, that the employee claims here, the employee plaintiffs, their claims have to be channeled through the CSRA. In your view, is there any other plaintiff in the case whose claims could support injunctive relief that includes enjoining the rifts?
Yes, I think.
And what would be that connection under CASA as to the specific injuries that have been claimed, and how would they justify injunctive relief that requires the reinstatement of employees?
Sure. So I think every other plaintiff would have standing to get relief that says that at least preliminary relief that says you can't conduct rifts right now. You've offered no lawful plan to this day. The defendants have offered no lawful plan to conduct a rift that would not shut down the agency. The only evidence we have in the record is that the defendants intend to use a rift in an effort to shut down the agency, and every other plaintiff is harmed.
Let's focus on, pick a plaintiff though, and explain why their claim would require all the employees to remain in place.
Sure.
I mean, there has to be a direct connection under CASA between those things.
Sure, and I want to go back to CASA, but take the National Consumer Law Center, for example. The National Consumer Law Center both provides trainings to and sells treatises to the CFPB, but it also relies very heavily in fulfilling its mission on the resources the CFPB provides. It relies on the reports that the CFPB provides about the credit card markets, about debt collection, about consumer complaints, and it uses those reports to provide information to consumer advocates. And let me explain why this preliminary injunction, how that's tied. I see on your face the question. So all of those reports, it is not a matter to issue any one of those reports or to keep the consumer complaint database functioning, which both NCLC relies on and the Virginia Poverty Law Center rely on. It's not just a matter of, there aren't 3 or 4 or any number of identifiable people who can do that. The effort to keep, for example, the consumer complaint database functioning to produce these reports involves employees across the agency. So it involves not just the consumer response department, it involves people in the IT department, essentially the agency.
So if an organization is harmed by the CFPB's failure to produce certain reports that they rely on, why isn't the injunctive relief that matches that saying, hey, CFPB, provide the necessary reports that are required by law, assuming that they are required by law? I mean, how does it support, you can't fire a single employee while this litigation goes forward? I don't see the connection there. I mean, yes, maybe reports require, not a particular employee to be reinstated, but there can be injunctive relief that just directs the agency to provide relief to the plaintiff based on the plaintiff's alleged injury.
Sure. So I think I want to say a couple things. First, I'll note that the argument you just made is found nowhere in the defendant's brief, except as an aside in their reply brief. So to the extent we're talking about an argument about a scope of the injunction argument, which I think is not jurisdictional, I think that argument has been waived, but to answer the question.
Well, we can't support an injunction that has no basis in law or equity or remedial principles articulated by the Supreme Court. So
to answer,
I wouldn't rely on forfeiture on that point.
To answer the question though, I think there are a couple answers to that question. So one is there are a number of plaintiffs here. They are all harmed in different ways. Virginia Poverty Law Center relies on the consumer complaint database, the National Consumer Law Center. There are pages of documents.
One of the injuries to the refs.
Sure. So without employees, the CFPB can't do anything. And then the question is, at a preliminary injunction stage, did the district court abuse its discretion in saying, you have only used RIFs to try to close the agency, and rather than having months of evidentiary proceedings and extended remedial proceedings up front, where we try to figure out how much of the agency do you need to preserve and exactly who do you need to preserve to provide X, Y, and Z report, we're going to say you can't, I'm going to restore the status quo. I'm going to undo the thing you did to terminate the agency.
So the idea is restore the nationwide status quo.
The act that, the answer to that is, I think, yes, because the act that injured the plaintiffs.
That's the position that was taken in dissent in CASA.
So I just
said you can have an injunction restoring the nationwide status quo, and the majority said those injunctions don't work because they don't match the injuries of the plaintiff to the injunctive relief. So to the extent you're asking for what the dissent in CASA said was permissible, where does that leave the plaintiffs on this injunction?
So let me explain why CASA is quite different here. So the first is, the question in CASA was, can you enjoin this policy essentially as to just the plaintiffs? And if so, does that provide them complete relief? It is not possible to say, don't shut down the agency as to the Virginia Poverty Law Center. It's not, and CASA explicitly distinguishes indivisible relief, and shutting down an agency is indivisible relief. So that's one. The second thing that CASA says is we're not talking about the APA, and the APA has its own, as Judge Pillard pointed out, its own preliminary relief provision. That's 5 U.S.C. 705. And it explicitly authorizes relief to preserve the status quo. And the third thing,
that wasn't the basis for the preliminary injunction here. Can we uphold the preliminary injunction under APA section 705?
So I'd have to go back and see if the judge cited 705 specifically, but just the judge certainly found that we were likely to succeed on an APA violation, and I think we assume
And then
that.
entered equitable injunctive relief.
I mean, I think that is equitable under
We
the
just, can we
APA.
just pull out remedies from the APA for, I mean,
So to the extent that you think that what the judge did is found a likelihood of success on an APA violation, but didn't rely on the provisions of the APA that allow her to provide relief, the court affirms on any basis in the records. The court could certainly say, this is certainly permissible under the APA, or if what the court wanted to do is
we
to
just
say,
replace an equitable preliminary injunction with a specific remedy under the APA.
I think if there's a
We can just swap that in.
I think the answer to that is yes, and it's well established this court can affirm on any basis, but if this court wants to remand and say to the district court, would you enter this injunction under the APA and give the district court a chance to do that? I think we wouldn't.
I'm sorry, affirming on any basis means taking a different legal ground to support what the district court did. I'm not aware of any authority by which we can impose a different remedy entirely.
I think the remedy is the same. The question is, I think to what you're saying is I'm worried after CASA that the Judiciary Act is not a sufficient basis for this preliminary injunction. But if we think the APA, which the district court found there's a likelihood of success on, is a sufficient basis, but the district court, and again, I'd have to go back to the opinion to see whether she called it out or the district court called it out or not. But we think that the district court should have explicitly mentioned the APA in the opinion, but didn't. I think that is certainly within some ground on which this court could affirm.
One thing I'm trying to figure out is on this tying the remedy to particular plaintiffs, and you talked some about, so to the extent there's reports, presumably it wouldn't satisfy the statute to just issue, wouldn't satisfy the statute for a shell of an agency to issue a report that says, here's our report on X, and it's empty. We got nothing, and they put that report out. And so it takes some number of employees or contractors to collect information across the agency, but I don't have a sense of, I mean, I think that was your point, if I understood it right, that you need to have other things operating to get the information that's needed for the reports. One, can you spell that out for me a little bit more to give me a sense of what's really required as opposed to desired to produce these reports? And second, is there a similar concern with this hotline? Because I know there were worries that they said, oh, we have to have a hotline, so they hook up an answering machine and it just fills up and no one's responding to these. Does that require cross office or across the agency information as well? This is to help understand better why this is indivisible when in some ways it sounds like it's not.
Sure. So there's some information in the record about this as a docket 127, and some of that information comes from the panel had exactly this thought that you're asking about, which is, what if we just limit the RIF provision, which is the thing that the defendants seem to care about, to to say you can RIF anybody who's not required to perform a statutory obligation. And what happened when the panel said that is the defendants tried to RIF virtually the entire agency again. And the record, the chief operating officer and the chief information officer and leaders across the agency submitted declarations saying that the agency would be eliminated within 60 days. So it is, quite.
I take that point. That's been well covered in the briefs and obviously in the record in this case.
Sure.
But for us, I'm trying to ask a more particularized question of understanding how or why you claim this is indivisible. So what makes it indivisible? What's needed to prepare reports? What's needed for hotline? What's needed for aiding veterans? Or disaster victims, just to have a better understanding here of that.
Sure. So let's take, for example, the Consumer Response Database, which the Virginia Poverty Law Center relies on, the National Consumer Law Center relies on. That requires, I think the record is, hundreds of employees to function, which is, keep the database operating, there are contractors who answer the hotline. There are people who deal with complaints. There are people who deal with emergency complaints. There's a large number of people, and there's a memo in the record about this. There's a large number of people that are required to keep that online. And it's not just the consumer response team that's required. So if you look at JA 1245, you'll see that they depend on the technology and innovation team. And that's several people. I'm not sure exactly how many people, to be honest, but it's several people who ensure that the technology functions. They also depend on the contract and procurement department. That's at docket 127.6, because there are a bunch of contracts required for all of the software to keep the database running. They depend on the research, monitoring, and regulations department to get people into the system. And they depend on the populations offices, the office of, for example, service members affairs, to deal with reports based on consumers who are covered by those offices. So even just if you take one function of the CFPB, you end up with reach that is across the agency, even just to make it functional. And that's true if you take it, any particular function that you can think of the CFPB, that's still true. And that's because the Bureau is so intertwined.
But
and
can't
the,
we go
sorry.
below what the last administration had when the new one took over? I mean, the difficulty is, as I think you mentioned, it could consume a lot of litigation, a lot of time, when the administration would really like to be getting on with its plans. If there's a lot of fighting over the preliminary relief, but at the same time, to lock them in to the max from their perspective, from where they started, feels like it's also wasting the time that this elected president has. So I guess my question for you, and also this is the flip side of my question for Mr. MacArthur, is what is the least that you think your clients could accept, that, like, what if we went back to the April 11th partial stay of the district court's preliminary relief that rolled back and said, look, if you do an individualized determination that these RIFs or these contract terminations are consistent with the agency continue to fulfill its statutory duties, and you present that, that you can do it as long as it's non-arbitrary, and the court can say fine. Fine with you?
In other words, the question is, if instead of the order that was entered then, it essentially asked the government to come into court first with a lawful plan or an assertedly lawful plan to conduct a RIF, and then the court can say, okay, I will modify the injunction to allow you to conduct the RIF. What would be wrong with that? Is that essentially the question?
Well, that's one version. Another version is they can do it without getting advance clearance from the court, as long as they actually, a lot of what the government does in general is subject to the APA. They should be, whatever they're doing, having reasoning behind their final actions. And as long as they had that in their pocket, and if the district court said, whoa, that looks crazy, or the plaintiff said, whoa, that looks like you're going back down the road of taking down the agency, they would say, no, here it is. So maybe they wouldn't have to get advance permission, but the assumption would be that they'd have some explanation of, there's 18 statutes. How are they planning to enforce them? There are obligations to supervise. What's their plan? I didn't see that the last time around, but if the understanding was that they have to do that, is there any reason why we couldn't go back to the partially stayed district court order that we embarked on April 11th?
Yeah, I think what happened after the April 11th order shows why the district court didn't abuse its discretion in entering that order in the first place. And I think it is exactly this distinction between allowing the government to do something and then having to have an enforcement proceeding afterward. What happened there is the government said, okay, we complied. We had a particularized assessment. And there wasn't ultimately an evidentiary hearing because the panel restored the initial preliminary injunction, but immediately, essentially, there was an email from the chief operating officer and the chief information officer that said, they say they conducted a preliminary particularized assessment, but what in fact happened is this agency is going to be eliminated within 60 days. There were declarations from across the agency, leaders from across the agency saying, nobody asked us what's required to perform our statutory obligations, and it would be impossible. And so and I think what that shows is that the district court has wide discretion in determining a scope of a preliminary injunction. And I think the decision that the district court made is I am faced with defendants who have taken action that they concede is unlawful. They submitted initially declarations to the court that the declarants themselves later conceded were untrue. The district court found.
They want everything and they want nothing. They want at most, and they don't even think that this is appropriate, they want a set aside order. We're just setting aside the shutdown. Everything else is open road, and you want the full restoration of the Bureau to its status quo ante.
I do think that the preliminary injunction that restores the Bureau to the status quo ante is correct. That's the purpose of a preliminary injunction. And then the question is, what do we continue to preserve through the lawsuit? And the district court was very explicit. The district court was concerned that the defendants had never presented, and to this day, we pointed this out again in our en banc response brief, you haven't presented a lawful plan. To conduct a RIF by law, you have to have a plan. And they still haven't presented any lawful plan. And the district court was really explicit. If you have a lawful plan, come to me, I will modify the injunction. And so I don't know that having this injunction in place prohibits, genuinely as a practical matter, prohibits the government from conducting a lawful RIF. What it prohibits the government from doing is conducting an unlawful RIF and potentially then claiming it that it is lawful, and it ensures that what we're not doing is either spending a lot of time up front when we should just be litigating the lawsuit, having remedies proceedings to try to finely tune exactly what would be necessary, or having enforcement proceedings all the time where the defendants say, okay, we RIF 99% of the agency, but we're claiming that it can pursue its statutory functions. Okay, you didn't like that. We RIF 98% of the agency.
All right, so in this case, the district court definitely was having to move very, very fast. And there's record stuff, at least one view of the record, that shows the agency was agency officials were trying to act before the district court hearing. So the district court had to react very, very quickly. So in your view, if at that point and the district court doesn't have time to have long hearings on the interconnection of everything that's needed to produce this report or that report or to run this hotline or provide this service. And so take it what you're saying is on such an emergency basis, things are moving very fast. And according to the witness, the agency is going to be gone in 30 or 60 days. So the district court could enter sort of a status quo injunction consistent with CASA, could enter a status quo injunction on the ground that at this fast look that I'm forced to do, it's indivisible, but then invite the defendant to come show, or maybe the burden's on you to come forward and show, now that we've frozen the status quo, that this truly is indivisible. I mean, it doesn't, it's not clear to me that, I'm not quite sure what's meant by what counts as indivisible and what doesn't. There's certainly some interconnected stuff here, maybe some other things aren't. But at some level, district courts have to have the ability to preserve their ability to hear the case before the agency disappears. But should the district court after that have, I know you don't want to spend all your time litigating this, but is there, whose burden is it then at that point to show that was the right scope of relief, it was indivisible, for them to come forward and show, no, it can be compartmentalized or narrowed? What case law tells us whose burden it is at that point after everything's been frozen?
Sure. So I think this court's decision in JD versus Azar is helpful here, and it's a quite a similar situation actually, which is to say it was clear that there needed to be some relief, and there were difficult questions that might go to exactly what the scope of the preliminary relief needed to be, which is to say there might have been some situations in which the government could have done some things lawfully that were prohibited by the preliminary injunction. And what the court said, what this court said here is, look, the government undertook a blunt action. Line drawing would require a complex inquiry. So instead of getting to the merits, we're spending all of this time trying to figure out upfront the line drawing question. And the government refused to identify any workable alternative. All they said is, well, you know, we'd like to do maybe some hypothetically legal things, but they didn't identify any of them. And what
I think they
JD
said it's not our burden, and I guess that's my question to you.
Right, and so
Whose
what-
burden is it?
Sure.
Again, let the district court freeze things, at least for some period of time, but what happens then?
So I
Is
think
is
what-
there a further obligation on the district court, or does the burden actually shift to the now enjoined party to come forward and has to reconsider or modify?
I think once the plaintiff has met their burden to show that this injunction, this preliminary relief is necessary, which is what the district court found here. And I'll note that that includes things like workability, administrability, not engaging in complicated remedy procedures up front. Once the plaintiff has met their burden to come forward and show that, then a preliminary injunction is a proper exercise of.
I know,
the
but
court-
I guess my question is, assume you made a showing for this immediate relief because this is complicated. And the district court had to do something very fast to just stop the shutdown in its view, as it found. Stop that shutdown. And if it didn't stop that, the case is gonna be over before it was over. But having made that showing that we need this quick immediate relief, is that sufficient to sustain a PI for the entire time a case is litigated in a post CASA world, or once everyone can catch their breath, just one of the two parties have an obligation to demonstrate that it couldn't be tailored in the way CASA talks about it, that it is truly indivisible.
So I think once the preliminary injunction is entered and once it's shown that it's necessary, which is what happened here, and I'll note there was initially a consent order that the district court put in place and that the defendants agreed to avoid TRO proceedings. So the findings that the district court entered were after a 2-day evidentiary hearing. And the district court found that this was necessary to preserve the status quo and to prevent harm through the course of the litigation. Once the district court enters that finding, I don't think CASA changes the ordinary law that if you want to modify that finding, you then come in and move to modify. And I think in this case, especially, the district court was very open to that. The district court said, if you have a lawful plan, come in and show it to me. And the government never did. To this day, the government still has not said, we have a lawful plan to conduct RIFs. All it says is, hypothetically, we might like to do that. And it's not an abuse of discretion to say, you know, when I entered an injunction, because I think it's necessary to prevent harm, and the defendant hasn't offered any identifiable lawful way in which that harms the defendant, that injunction is necessary, especially given the workability concerns in this case. You know, the other option, again, is the one there are a couple other options we've talked about. One is essentially a follow the law injunction, don't shut down the CFPB, which would not have any specifics. A second is what the panel tried, and that ended up with essentially immediately trying to shut down the CFPB. And then you have what's here, which is, let's get to the case, let's figure it out. And I think, you know, this case could proceed quite quickly given the strong record in this case. Let's figure it out, and then we'll have a remedies proceeding pretty quickly, and then we can tailor final relief. And hopefully the government would be more willing to engage in that process than it was up front when it was hoping to have. It didn't want to tailor the injunction because it wanted to be able to stand up here and say it's too broad. So it didn't want to help tailor the injunction. Hopefully that would be different in a remedies proceeding.
Is that what, because a few times you've kind of caveated your remarks about the relief by saying at least preliminarily, at least preliminarily. And is that what you're getting at? That
Yeah.
that's one thing to do for the interim period while the litigation is pending, but that doesn't speak to what would happen once the merits were gotten to.
I think that's exactly right. And that's because, you know, what the Supreme Court and what this court has said is part of when you think about what's necessary for an injunction, one consideration is workability, it's administrability. And the way that applies in a preliminary injunction posture can be a little different because, as Judge Millett, you say, it's a stopgap. It's not going to be in place forever. And the point is to try to get to the end sooner, and then you can have remedies proceedings where you figure out what is going to happen in the end. And
Is workability an exception to CASA's requirement that there be party-specific relief?
no,
So
it's
in the
not.
preliminary stage, if you know, a narrower, you know, if a broader injunction just sort of holds everything in place, that's an exception to party-specific relief? Like keeping the agency frozen exactly as it was before the last presidential election, that's because that's more workable, then you can avoid the party-specific questions.
So I want to make 2 points on that. The first is workability is not an exception to CASA. CASA makes really clear when we're talking about an injunction, preliminary or otherwise, the scope of the injunction is tailored to what's necessary to provide complete relief, and workability has always been understood as a factor
To the
of
parties,
sure, between
not
the
to the
parties.
world.
Agreed. And workability has always been understood as part of what you consider when you figure out whether a preliminary injunction is necessary. The second is, I want to make clear, this preliminary injunction does not freeze the agency. As what it was in the Biden administration, the preliminary injunction, in fact, says nothing at all about any of the policy decisions that the agency can make. It also allows the agency to terminate any of its contracts. It just prevents them from finalizing it such that it can't be done at the end. And it allows the agency to fire anyone it wants for cause. So the district court tried very hard to come up with as narrow of a preliminary injunction as it could that would ensure that the status quo with respect to the parties was preserved through the course of the litigation without having to mire it in constant enforcement proceedings.
Can I just see if I can clarify something? I mean, at some point, you know, after the statute creating the agency was passed, you know, the executive stood up the CFPB. And it seems like what I understand your friend on the other side saying is that, you know, it could be stood up again. So help me understand why the district court has to take action to prevent the shutdown of the agency, because that is in and of itself irreparable. Why can't Humpty Dumpty be put back together again? Why can't the agency just be, at the end of the litigation, be stood up again? Help me understand that.
Sure. So I'll note that the defendant's only witness in this case said the harm would be irreparable. But let me tell you why. It is not impossible, of course, to build an agency. When Congress passed the Dodd-Frank Act, it took a year, even between just passing the act and for the agency even starting to exist. And then it took longer after that for the agency to actually be able to start fulfilling its functions. So it's not that you could never build an agency. Of course you can build an agency, but it would take a very long time to do it. And in the interim, what you would have is consumers not being able to use the consumer complaint database, which means that they would be have things like foreclosures happening to them with nobody to help. They would be unable to get their car loans because they have inaccurate credit reporting. There's a host of things that would happen in the interim of a year or more to stand back up this agency, because when you end it, you eliminate all of the offices. So you have to create all of the offices again. You eliminate all the contracts. The procurement process takes 6 months to a year or more. You have to build it up from scratch, and that takes a very long time. And what Congress did is it transferred a lot of functions from other agencies to the CFPB. And those functions are not being performed by anybody else now. So if the CFPB ends, as the Supreme Court recognized in SALA law, you would have a very substantial disruption to the economy and to the financial markets in the interim. And so the problem isn't that you can't ever stand up an agency. The problem is there are a number of functions that the CFPB is uniquely performing right now that just nobody would be performing at all if it disappeared. And it would not, nobody would be performing them for a year or 2 years. And that's really the problem. So if I can move to, unless there are further questions on the scope of relief, I want to just quickly touch on the APA. I realize actually I realize I've well exceeded my time.
If you want to make a quick point about the APA, you can.
I think unless the court has questions, I'm happy to do that if the court has questions, but unless the court.
Well, could we address the constitutional claim without first addressing the APA and also vice versa?
I'm sorry, I didn't hear that question.
Could we be addressing the constitutional claim without addressing the APA and vice versa, or will we have a constitutional avoidance issue?
I think you could really do either one, but I think we do have relief under the APA. I think it is final agency action. I hear you. Essentially, your question is, if you win under the APA, do we have to reach the constitutional claim? I think the answer to that is no. And I'm happy to briefly touch on the APA claim. The one point I would make on the constitutional claim is I heard the argument that what Dalton says is, if the government says we don't have any statutory or constitutional authority, it's not a constitutional claim. I think that is directly contradicted by the text of Dalton, not just by the existence of Youngstown, but by the text of Dalton, which says, and this is a quote, it's describing Youngstown, because no statutory authority was claimed, the case necessarily turned on whether the Constitution authorized the president's actions. Which, in other words, what Dalton says is, if you don't claim any statutory authority, it is necessarily a constitutional question, because the separation of powers requires that the executive have authority to, especially in this case, fundamentally restructure the government. To answer the APA question,
just on that
Sure.
point, I mean, isn't Youngstown factually distinguishable? Because there the government undoubtedly took an action, seizure of the steel mills, for which it claimed no statutory authority, only inherent constitutional authority. But here the government says, we're not shutting down the CFPB. We're taking actions that are deregulatory. We're making it smaller, but they don't claim to be shutting down the CFPB. So it seems strange if they're not claiming to do that, to then attach to them the same reasoning of Youngstown.
So I think that's really a question. I think that's the clear error question of whether the district court was correct in the factual finding that the defendants were in fact shutting down the CFPB. I don't think it can be that you can avoid a constitutional claim by just saying, like, if the president came in Youngstown and said, I didn't seize the steel mills, I was just putting locks on doors and sending buses of employees to run them. I don't think that would get you out of a constitutional claim. I don't think I don't know that there's any authority for the fact that it turns on what the government claims it's doing. The question is, what did the government do? And the district court found that the government was trying to shut down an agency that Congress created. And then the question is, does the executive have authority to take that action?
Why doesn't it turn on the nature of the claims or defenses? I mean, for better or worse, the whole law of reviewability is based on this idea that it should be easier to get judicial review of constitutional disputes than of statutory disputes.
I think that's right. I mean, so I think that it turns on, the question turns on, is there an allegation that there is a violation of the Constitution? And maybe I'm not quite understanding the question, but if the fight is about, did the executive violate the separation of powers? I think that is a constitutional claim where the executive is trying to fundamentally restructure the government without any authority from Congress. I think that's a constitutional claim, regardless of what the claims or the defenses are. But maybe I didn't quite understand.
Well, okay, well, let's talk about that then. What line would you draw to distinguish statutory claims that are just statutory claims, even though every time the executive violates a statute, the take care clause is in some sense being violated? Distinguish that from what you think we have here, which is something more that constitutionalizes things for purposes of the law of judicial review?
Sure. So I think we have quite an extreme case here, which is the executive claiming a power to create, or in this case, destroy an agency, which the law has been clear since McCullough v. Maryland is the power that Congress had. I think the easy case is where the executive claims a power and authority to restructure the government. That's a separation of powers claim. The way I would.
What's the line?
Sure. The way I would express it, and I recognize there's going to be some hard cases in the middle. I don't disagree with you. The way I would express it is essentially what I think Dalton says, which is if a statute gives you authority to do, gives the executive authority to do something, but the executive does it wrong. So the executive in Dalton, for example, actually what the Supreme Court says.
It's excessive authority versus no authority, some variation on that.
Yeah, and I agree with you that there might be hard cases in the middle, but that is what Dalton says. And I'll note that Youngstown could have been a statutory claim. You know, there were statutes in Youngstown, there were statutes that authorized the executive to seize certain things under certain circumstances. And that didn't stop the court from saying this is a constitutional claim, and it didn't stop Dalton from characterizing it as a constitutional claim. And that's because fundamentally the act that the executive took without authority is fundamentally a legislative act that the executive cannot take.
What role in the Dalton calculus, in response to the exchange you were just having with Judge Katsas, what role, if any, does it play for you that the executive is not claiming that it has statutory authority to do the thing that you said it did? So it's different because you say there was an agency shutdown. The executive says we never meant to shut down the agency. We're just downsizing. We're trying to be responsible stewards. We're just downsizing. If that's the situation and there's no dispute on whether there's authority under the statute or the Constitution for that matter, but at least under the statute to take the action that you allege has been taken, does that matter for Dalton purposes? Is that just irrelevant or only turns on the way the plaintiffs pitch the claim, or does it matter the stance that the government takes on whether they have authority to engage in the action that you allege they engaged in?
I don't think ultimately it matters legally whether the government says, yes, I have authority, or no, I don't. But I do think it makes it a particularly easy case that the government concedes it has no authority, statutory or constitutional, to do the thing that the district court found that it did.
Why does it make it an easy case for purpose? I mean, it might make it an easy case on the merits if in fact the government did it. I understand that. But why does it make it an easy case for purposes of Dalton, the Dalton question of whether there is a constitutional action?
Because there's no question, there's no hard line drawing question about whether the defendants exceeded their statutory
Okay, so it
authority
gets
or
back
just
to lack
didn't
of
have
authority
any.
versus
So
excess.
so I'm sorry?
It gets back to lack of authority versus
Exactly.
excess authority. It's an obvious lack of authority case if the executive is not claiming they have
Exactly.
authority. I mean, I suppose they could do that with an excess authority too. They could just say, "Why? I mean, I don't think it exceeds. I think it would exceed my authority. I'm not saying I don't have any authority in the area, but I acknowledge that it would exceed my authority. But I didn't do that actually."
Sure, and I think then you would have the potential question of whether it's just an exceeds authority case or whether it's a lack of authority case. But because the government has resolved that question for us, it has been very explicit. And I think it's correct to do this, that it has no authority to shut down an agency.
On the Dalton point, can you distinguish the Fourth Circuit decision in Sustainability Institute, or would we have to create a circuit conflict to rule in your favor on the Dalton point?
I don't think it would create a circuit conflict there. I take it with the
Wholesale shutdown of major grant programs. The argument for constitutionalizing is, look, this is a macro structural problem, not a micro narrow case, and the court says none of that matters.
As I understand what the Fourth Circuit held, it held that it is potentially a macro question, but it is a macro question where there is statutory authority, and including statutory authority to, what I understood the Fourth Circuit to hold is there is statutory authority to essentially withhold this money to terminate these grants and the government just made, the claim is really the government didn't follow the correct procedures, there is no statutory authority to shut down the CFPB. So I don't think that this court would have to split with the Fourth Circuit. I do think if the court were to accept the defendant's position, it would be splitting with the Ninth Circuit in Murphy, which made very clear that just because you might also violate a statute doesn't mean you're not violating the Constitution.
Don't we, just as a matter of constitutional avoidance principles, though, always have to address the statutory question first?
I absolutely think it would make sense here to address the statutory question first. I think we would win on the APA. And when I understand, I'm sorry, go ahead.
What I was going to say, but I think a long time ago, Judge Childs had asked you to talk about that argument. So I'm wondering if I can resurrect that request.
Yes, I agree that it would make sense to address the statutory question first as a matter of constitutional avoidance. I don't know that this court has to do that, partially because the court is not ruling on whether the action was unconstitutional. And in fact, the defendants concede that that shutting down an agency is unconstitutional. So it's not really a constitutional question. It's a question about the existence of an equitable cause of action under certain circumstances. So I think the court could reach that question without implicating any constitutional question. But I think it would also be perfectly reasonable to say we're not going to worry about that. We're just going to rule on the
The
APA.
equitable, maybe I'm wrong. I assume the equitable cause of action would definitely be subject to CASA limits in a way that APA relief may not be.
I think that's right. I don't think APA by its terms, I don't think APA relief is subject to CASA, or at least I think it's clear that the Supreme Court did not rule on that, and there is a separate statutory provision. I agree that the equitable relief under the Constitution would be subject to CASA limits, but for all of the reasons we discussed, I don't think that there's any problem there. On the APA, what I take to be the defendant's argument, the only real argument that I think they're making now is essentially it's not final agency action. And I think there are really only three potential ways you can get there. One is shutting down an agency isn't final agency action. The defendants have conceded that's not what they're saying. They're not saying it's never final agency action. The second way you can get there is we didn't shut down the agency. I think that's would require you to find that the district court's finding was clearly erroneous. I'm happy to talk about that, but I didn't hear many questions about that. And then they're just left with the argument that it is final agency action, but there's something different about it if at the preliminary injunction stage, it's not, you don't have a writing, I think, or maybe just you don't have an expression. They're not really clear about this. And that's partially because it's been a moving target throughout the litigation. They didn't raise this argument in the district court. The most recent version in front of the en banc court is it has to be some sort of expression. And I think that that rule would require this court to overturn a number of its cases, including the Hispanic Affairs Project, which I think is quite similar here. The government made almost exactly the same argument there as it's making here, although there was at the summary judgment phase, where the plaintiff said, alleged there was a de facto policy of treating certain kinds of visa applications a certain way. And they submitted a bunch of declarations that says, as a matter of fact, here's what's happening on the ground. And the government came in and said, well, you don't have any memorandum, you don't have a writing, you don't have a statement, you're not saying who made this decision. And so you really either have a statement problem or you have essentially a Lujan problem. That's virtually exactly the same argument that the government is making here. And what the court held is, you don't need it to be written down. The question is, does the agency have a policy or has it made a decision that it's affecting the rights and obligations of the plaintiffs? And the answer there was yes. And then with respect to Lujan, what the court said is similar to what Judge Pillard said about the footnote in Lujan is, look, Lujan explicitly says if there's an overarching policy or decision that you're challenging that governs all of the essentially implementation actions, that is final agency action and you can challenge that.
Sorry. Even if the so-called shutdown here was an agency action, why is it not clearly erroneous to find that it was final? So even accepting some of the findings that there was some kind of shutdown underway, then there's a whole series of communications showing that what they were really doing is putting a pause on what was happening and trying to figure out what the statutory minimum was, right? Go forward with statutory required functions. And so even if there was some agency action, which I'm not entirely convinced for a shutdown, why was that final agency action in this context? What was the final agency action?
Sure. So the final agency action is deciding to shut down the agency. As the chief operating officer testified, it would have been eliminated absent the district court's intervention. And I hear what you're saying is, well, there are some emails that went around that seem to suggest that that the agency was in fact just downsizing, was committed to performing its statutory functions. I'll note I'm a little surprised that the government continues to make this argument in light of the fact that just before it filed its brief in this court, the acting director of the agency publicly stated, we're trying to close down the agency and we want to put it down. I expect we'll succeed in 2 to 3 months, which I assume was the length of time that he had been told the en banc process might take. So I'm a little, and asking for the first time on appeal for the presumption of regularity when it didn't ask for that below and is making public statements. But putting all that aside,
Go to
assuming
where the shutdown was a final agency action. Like even if at some moment in time, the stop work order or something that the district court pointed to was an agency action for a shutdown, so-called, why was that final based on all the other evidence in the record?
Sure. So I think there are potentially 2 ways to look at it. One is, I think the question is, I don't think there's any real dispute that there was a decision made to shut down the agency, and they were in fact shutting down the agency.
Why was it final?
Sure.
How was it final based on the record before us?
So it's final because we know it's final because the chief operating officer was going around telling everyone that that was true, and they actually implemented it. So they were in the middle when the district court intervened. They were in the middle of eliminating every single position in the agency. They had terminated they were terminated virtually all of the contracts, excluding, I think there were 2 exclusions. One was litigation, the database that had litigation data, which they're required to preserve, and the database that had employee data, which they're required to preserve. They had eliminated every single physical office, even though there was an executive order saying that agencies must be in person. They had gotten rid of the website.
Then what about all the actions, in emails suggesting that people should go forward with statutorily required functions?
Sure. So what the district court found, I don't think this is clearly erroneous, is that those were created for the district court's consumption. And I'll just point out a few of the district court's reasons for that. There are a couple things that the defendants relied on for the proposition that they, maybe they were trying to shut it down, but they have since voluntarily stopped doing that. The first is the declarations of Chief Operating Officer Adam Martinez, who on the stand and in a second declaration testified, actually, I was wrong about that. And he said that the information he was given that was wrong was given to him by agency leadership, and he now knew that it was not true. So those declarations are out, and I think it's not clearly erroneous when a declarant says, I now know that my declaration wasn't true, to not believe that declaration.
If we're trying to assess whether it was final agency action, do we have to look at what was before, what was happening in the agency at the time when the district court ruled? And so this after the fact material doesn't really, is it even permissible to look at it? I mean, I could see evidence coming to light that existed at the time of the complaint might be relevant, but post shutdown conduct, is it relevant?
I think it is potentially relevant. It's relevant as a voluntary cessation argument. The defendants
That's
aren't
separate.
making
That's
that
different.
argument.
Right.
And so I do think it's relevant that way if the
But
defendants.
they are not making that.
They are not making that argument. They have explicitly disavowed that argument. I think the reason they're not making that argument is because it would be in conflict with the argument of we never tried to
Right.
shut down the agency.
Right. But if we were to sustain the district court's finding of fact that they were,
Yes.
then it would be open to them. I mean, they could seek further review. And if that's not successful, then they might turn their minds to a voluntary cessation showing, and that would look to these kind of emails and more. But I'm just trying to understand your position in rebutting them. It seems like, the first line of argument is, well, she was looking at whether the complaint stated a claim that there was final agency action, that they were shutting the agency down.
I think that's right. I do think that the evidence leading up to and that she heard at the preliminary injunction hearing, I do think that is relevant to determining whether a preliminary injunction is necessary. And one thing that would go into it is have the defendants voluntarily cease their conduct. So I don't think it's irrelevant, but
Or even how, maybe less than that, how gung-ho do they seem? I mean, I think part of what is challenging in this case is the speed at which the action was being taken. I mean, the notion that it's non-final when it was like, we can't wait till close of business, that it was breathtaking how quickly action was from, you know, level A to 10% of that.
I think that's exactly right. And I think even if you wanted to take into account what I think is their best evidence, I think the district court did not clearly err in rejecting that. So for example, they identify the average prime offer rate. They say, you can keep working on this. This is statutorily required. It's an interest rate that matters to the mortgage industry. And they say that shows that we're complying with our statutory obligations. That whole team that does that work would have been eliminated on February 14th as part of the RIF had the district court not intervened. So finding that the claim that showed they were going to comply with their responsibilities when they were going to RIF every position that was necessary to do that, I think was not clearly erroneous.
Can I ask you about a little hobby horse of mine, which is supervision?
Yeah.
Now I know enforcement is deeply discretionary. I mean, it's not discretionary to abdicate it altogether, but it's discretionary what priorities you have. What about supervision? Is it, how much play in the joints is there? And what is the supervisory responsibility of the Bureau?
I would want to go back and just double check to make sure I get it right. I think there certainly is a statutory requirement to have supervision and to supervise, and particularly the CFPB is the only agency that has supervision authority over large banks. So banks over, I think, $10 billion and also non-bank financial institutions. There are statutory obligations to conduct supervision. I do think that the agency has some discretion there about how it exercises that authority. I'll note that the district court did not purport at all to try to control that, even though I think, you know, the district court potentially had a little bit more room, but did not, you know, intentionally didn't include anything that would try to control anything about which the agency has any discretion.
Can I ask one question about the relationship between the APA action and then the equitable constitutional action? So if we were to conclude that there is no final agency action for APA purposes, resist that, but let's just hypothesize that that was the conclusion. And then we assessed whether there was a constitutional problem with the decision to shut down the agency that the district court found. Is there something that's incongruous about saying that there's no APA action to look at the agency shutdown because it wasn't final enough, et cetera, et cetera? But there is such a decision for purposes of assessing an equitable constitutional action.
I don't think so. I mean, the only argument I have heard about finality, the only real argument I think the defendants are making now about finality is this question of expression. I think that is incorrect and happy to talk about that, but I don't think there's anything inconsistent between saying we're not going to hold its final because we think at the preliminary injunction stage you have to show an expression as opposed to a likelihood of success on that, or that's not required at all, and saying there was this action under the Constitution. I don't think there's anything inconsistent in that.
You, sorry. Response to Judge Rao's question about what do we do about these emails and stuff that came out, you said you had 3 answers. I think you only got 1 out, and I was interested in hearing the other 2.
I'm sorry, I didn't hear that.
Sorry, I'm losing my voice. I think.
It's only been 6
I think you
hours.
said in response to Judge Rao, maybe I'm wrong, that you had 3 responses regarding her question about what do we do about these emails that showed that no, we don't mean to shut it down completely. We mean to strip it down to what the statute requires. I thought you said you had 3 responses to that, and we only got the first one out. I was just interested in hearing the other 2, but if
Sure.
I've miscounted? And
I'm not
never mind.
sure what I was counting, so I'm not sure if you miscounted, but I will give you the list. One is, I think that's a voluntary cessation argument, which they haven't made. The second is here's the three record reasons. The first record reason is the one that we were talking about, which was initially and throughout the district court proceedings, the defendants were relying on these Martinez declarations, which he disavowed. The second is the defendants were relying on this email sent the day before the hearing by the chief legal officer saying, oh, I didn't realize nobody was working. You've all misinterpreted it. What I really meant is for everybody to be doing their statutory obligations all along. And the district court found that that was created for the court's creation, for the court's consumption. I don't think that was clearly erroneous. For example, the court cites evidence that being reactivated on paper didn't mean that anybody could actually do the work. So there's a number of declarations and evidence in the record that people couldn't actually work, even though there was this email supposedly letting them. And in fact, some employees got a text message after this email went out that said, do your statutory obligations. They got a text message on their private phone that said, don't do anything. These are at JA 716.
Text message from whom?
From their supervisor, from their manager. So that's at JA 716 and JA 662. The supervision division got an email that says stand down. The only thing they were allowed to do was provide a report to acting leadership. The stop work order wasn't ever rescinded. That's at JA 718. The head of the RIF team testified and the chief operating officer confirmed that throughout this time, the team kept meeting and they were meeting in order to plan for when the district court's order was lifted and they could again eliminate every position in the agency, and that plan had never changed. That's at JA 664, JA 1238, and JA 1131. There was still no office space. There to this day is no office space, despite an executive order saying agencies have to be in person. All mandatory training was canceled. There's still to this day a tip line to report people who are working in violation of the stop work order. And again, recently Vought went on a podcast and said, we're trying to close the agency, we want to put it down. So I don't think it's clearly erroneous to not rely on that email. And then the third tranche of evidence that the defendants say supports their position, there were three things that happened essentially before this email. One is the average prime offer rate email, which we've talked about. Another was the Home Mortgage Disclosure Act. It's another statutory obligation. There was an email about that. Similarly to the average prime offer rate email, the office that handles that work was going to be eliminated in the RIF on February 14th, had the district court not intervened. So the email saying, hey, office that's not going to exist in 2 days, you can keep doing your work. I don't think it was clearly erroneous to find that that didn't show that they weren't shutting it down. And the last is an email about consumer response. And what the chief operating officer testified is that consumer response was one of the things that if they publicly shut it down, they were concerned about public backlash. This is at JA 988. And there was widespread media attention when that got shut down. And they turned on the public facing part of that after this widespread media attention, but they didn't do anything to make it effective. So the contracts that were needed to operate still were terminated. The employees that were needed to operate it were still on administrative leave. And the plan was to get rid of every position that was needed along with the rest of the agency to operate that database. And so again, you have an email that says we're doing this thing, but actually nobody is doing it. And the plan was to eliminate everybody who could do it. And so those are the three sort of tranches of evidence.
My colleagues don't have additional questions for you. Thank you, counsel. MacArthur will give you the 5 minutes you asked for rebuttal.
Thank you. Happy to take any final questions from the court on any issue in the case. For my part, I've got 2 points that I'd like to touch on. One on this question of finality versus voluntary cessation, and how to think about that, and then I'll circle back to the scope of the preliminary injunction. And on the first point, I think I'd like to frame it by setting out what I take to be 3 distinct but related factual questions in this case. First factual question is, did the acting director in early February make a decision to shut down the agency entirely and cease performing its statutory duties? That's obviously the predicate for everything the district court did here. Second question is, did he ever express that decision in any final and binding way? That goes to whether there was final agency action under the APA. The third question, even if you answer the first two of those in the affirmative, is was that decision still in force in late March when the district court entered the preliminary injunction? Because that was the basis on which the district court decided that a preliminary injunction was necessary. That absent that injunctive relief, these defendants, while conceding that it would be illegal to do so, would nonetheless proceed to close the Bureau entirely. So even if you rejected our arguments on those first 2 points, if you conclude that by late March, any plan to shut down the agency has been abandoned and that the district court's finding to the contrary is in error, then this injunction was an abuse of discretion because it was entered on the basis of a clearly erroneous factual finding. There was also never, happy to give you chapter and verse on this, there was never any agency approved plan to RIF the entire workforce. Quickly on the scope of the remedy. Even if you reject all of our merits defenses in this case, I haven't heard any cogent, persuasive argument for how you can get from these plaintiffs' injuries to the terms of this injunction, which sweep far beyond what's necessary to remedy the injuries that they are alleging.
So
I don't
if
know
you-
why this
If you
is.
have an issue with the scope of the injunction, shouldn't you be making a motion in the district court to modify the injunction? I just don't think that we're well equipped to tailor an injunction. The district court is closer to the facts. It seems that it's her injunction. If you want to modify it, it seemed to me that, wouldn't that be the appropriate course?
We may yet do that, but it's not our burden to go in and move the district court to modify an injunction that was entered in error because it is overbroad. You may recall that this, our appeal of the preliminary injunction was litigated very quickly. The injunction was entered in late March. It was set on a briefing schedule, fully briefed and argued by mid-May, 6 weeks later. So jurisdiction had already transferred to this court at that point. District court lacked jurisdiction to modify the injunction, but
But
the-
even if we think it's overbroad, we should just remand and let the district court decide in the first instance, shouldn't we?
you should vacate and remand because entering an injunction that's overbroad is legal error. So yes, vacate and remand would be a proper remedy on the scope of the injunction issue.
Even if we don't vacate, if we think the injunction's appropriate but overbroad, we could remand.
I mean, I suppose if you conclude it's not overbroad and that wasn't error, remand would be one possible remedy, but I don't see how you could possibly conclude that this injunction is not overbroad. Once you get yourself out of the framework of these plaintiffs are here to save the agency and into the proper legal framework of these plaintiffs are here to remedy their discrete injuries, I don't see why this is so complicated.
No, I understand. I'm just asking you a procedural question, which is who should do this first? And it seems to me the district court should do it first. Do you agree?
Should
Should
do what
consider
first?
the breadth of the injunction and the appropriateness of the remedy.
I think the district court had an opportunity to consider the breadth issue when the court entered the injunction. We did make the argument below that the proposed injunction was overbroad because it was not tailored to these specific
It
plaintiffs.
did that with a gun to the agency's head.
Pardon?
It did that with a gun to the agency's head and in a pre-CASA world. Right?
I'm not sure what you're referring to.
The district court made it its fast hearing and made its fast decision when there was, in its findings, a gun to the agency's head. It was gonna be gone. And it did that in a pre-CASA world. And so if the agency has now taken her fact findings, accepting them as it's not clearly erroneous, if the agency has now changed its mind and its approach, it seems to me that's on the government's shoulders to come forward.
Well, the planning has continued, and if it's of interest to the court, that's something that I could,
The planning,
the planning for what to do with this agency if and when an injunction is vacated or modified so as to allow us to proceed with a RIF, which is a lawful measure that the agency is allowed to take. And if it's of interest to court to see those plans, that's certainly something that I can take back to my clients at the CFPB. But that doesn't change the fact that this injunction was entered in error, whether or not there was a gun
are
to
you
the-
offering to share with us your plans forward? What to do if the injunction is lifted?
I mean, if that's something of interest of the court, I can certainly take that back to my clients and we can have discussion about that. But it's not, again, it's not, district court doesn't get to enter an overbroad injunction and then put the burden on us to come and say, this injunction that was entered in there, you now have to move to modify it or proceed with your RIF plans under the district court supervision upon pain of contempt, like occurred when there was a partial stay of the preliminary injunction.
McCarthy, I was just interested in your answer to a question the Chief Judge asked Ms. Bennett, which is if there is no APA final agency action here, does that have implications for the equitable constitution claim? Is there some connection there?
So for an equitable constitutional claim, you wouldn't have to meet the various APA requirements necessarily. I still think some of those doctrines should inform how the court would think about an equitable constitutional claim, because one of the reasons why we have a finality doctrine in the APA and ripeness, which is not just an APA doctrine, but also one that you would think about in the constitutional context, is precisely to give agencies the breathing room to alter a tentative position and to course correct. And even if you think that there was an initial decision to close the agency entirely, which we do vigorously dispute, that the record supports that conclusion, the record clearly shows that in the subsequent weeks, the agency was taking numerous steps to ensure performance of statutory duties and had abandoned any initial intent to close the agency entirely.
Mr. McCarthy, if we were to vacate the injunction as overbroad, and then on remand, the district court were to conclude that the February 10th email was final agency action, and the district court then vacated that final agency action and did nothing more than that, they said case closed, what would you do?
I don't know exactly what we would do, but that sounds like not something that we would have a particular objection to, vacating since overtaken by events directive during a short transition period, not to do work without agency approval. I don't think we would have any issue with that.
And then if you proceeded to do some of the discrete things that the plaintiffs allege are illegal, what do you think they should do?
I suppose it depends on what the discrete thing is.
Let's say you shut down the hotline, and let's say there's a plaintiff that's injured by it. What should that plaintiff do?
That would be a 706(1) claim under the APA. They can bring in action for agency action unlawfully withheld. And that's actually a good point, Judge Walker, because we don't think any of these plaintiffs has actually proven up standing. But if the agency were actually to shut down, there would be thousands of plaintiffs almost immediately with standing and a cause of action under the APA 706(1). All you would need is a plaintiff who wanted to call in a complaint to the hotline. If that hotline's down, they have an immediate claim that they could bring to court. The court could order the Bureau to reestablish the hotline, and to do that, the agency would have to exist.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Stand, please. Honorable court now stands adjourned until Thursday, February 26th at 9:30 a.m.